Good morning, Mr. Lee. This is Mr. Albright, just checking to see how the audio is in a new
You're
look.
good.
Okay, thank you.
Good morning, Mr. Lee.
Good morning, Judge.
Are we ready to proceed?
Yes, sir.
Thank you, sir. Good morning. This is day 4 of the hearings in the P&M rate case. We had Mr. Cervantes on the stand when we recessed last night at almost around 5:30. So I would like to continue with his cross-examination by staff. Although before we do that, Mr. Cervantes, could you bear with us for a second to see if we have any housekeeping matters to address? Thank you, sir. Are there any matters to address before we move back to taking evidence?
Mr. Examiner, Keith Herman with the Water Authority.
Yes, sir.
I'll just note sometime this afternoon between lunch and 2 o'clock, we'll be switching counsel between myself and Dal Harris.
Okay. All right. Thank you, Mr. Herman. Anybody else?
Kelly Gould for NM area.
Morning, Ms. Gould.
Good morning. I sent PNM hearing examiners, Mr. Lee and the parties, NM area's cross-examination exhibit 42. I wanted to have that formally admitted into the record and into the Dropbox.
Okay. And speaking of Dropbox, while I'm awaiting PNM's response, I want to ask a question though. I assume when I say you can go find the document in Dropbox that you still have access to the documents. It's just that you can't get in there and manipulate anything in the folder. Is that right? Or the folders?
Yeah, so it is my understanding that the Dropbox would update in real time so that the link is simply functioning as a destination target to a cloud folder, and whatever is placed in there on an ongoing basis, you can download. But the tricky part is if depends on what operating system you're utilizing, and sometimes it's simply all you can do is download everything. So if people are updating the folders, then they have to download everything, and so you end up downloading everything 10 times.
Well, thank you, Hearing Examiner Ryan. My point is that I've been assuming that when I say go to the Dropbox folder, you'll see that I removed AN76, for instance, that I withdrew yesterday in reaction to PNM's objection to that. Or when I've taken a couple of the exhibits like PNM's or like in the administrative notice record that required additional pages included, and I talked about that this morning. When I say they are now there, corrected, folks can go in and access those revised documents. I'm hoping.
Yes.
What folks cannot do, and what we used to do and we really shouldn't do anymore, is allow folks to go in there and change their own exhibits around. We have to have somebody who's in control, the custodian of the record, so to speak, or the custodian of the Dropbox folders, and that group are the hearing examiners. And so I want to make sure, speak up now if you have not been able to access the Dropbox folders. And this is the last reason I'll mention this, is because we need to move in real time. And so the witnesses and the attorneys have to have access to Dropbox at their fingertips in order to move the case along when we're referring to exhibits, if possible. Are there any questions about Dropbox then? Okay, Ms. Terwilliger, regarding New Mexico area cross-examination exhibit 42, what is the company's position?
No objection.
Thank you. So New Mexico area cross-examination exhibit 42 is admitted.
Thank you, hearing examiner. I have two other questions. One is NM area had previously requested administrative notice of certain documents, and I was wondering if those documents would eventually be listed on the commission's administrative notice folder or list, or if the commission's administrative notice list was purely for Four Corners issues.
Well, that's the other reason I started this morning with Dropbox, is because it occurred to me overnight while I was having another one of my great nights of not sleeping. I remembered I have to renumber all the exhibits in there 1 through 75 or 70, 74, 75, whatever. And I wanted to make sure that you all could go back in there and see, so that when we're cross-referencing and we're talking about one of those prudence issue exhibits, that we can all be on the same sheet of music, so to speak. So with regard to other documents that we'll take administrative notice of, I defer to, or at least confer with hearing examiner Ryan, but my instinct is to say, let's keep that let's keep it separate, because we'll be talking about potentially admitting bench request responses, maybe even as early as today. And those will go in the regular exhibit Dropbox folder, not the administrative notice folder, which I, unless hearing examiner Ryan overrules me, I would like to maintain that folder specifically only for the issue of prudence from 16 to 76. Hearing examiner Ryan, is that okay with you?
Of course, yeah.
Okay.
Okay, so my understanding on your ruling is that the documents that we've requested administrative notice of are administratively noticed, but they're not going to be in the Dropbox in that specific folder
they're-
titled
they're-
administrative notice.
They're not going to be in that folder. And if you want to prepare, if you want to prepare those documents, let's keep them separate. Let's not put them in there, because I know the ones you're talking about now, they go back to rate 36B and
Yes, they're
the tariff, the various documents around the special services contract, right?
correct.
In fact,
and
the
also
contract, excuse me, the contract itself. I'm a little bit slow. You're probably ahead of me in caffeination. I was able to make my coffee, just not consume it entirely yet. So apologies, but is that correct?
Yeah, there are several documents that have to do with rate 36B, and then also we've
Yeah.
requested administrative notice of the NARUC manual. We can provide a list. It would be helpful, I think, just for the record. We don't want the documents in the record, right? That's the point of taking
Right.
administrative notice. But I think it would be helpful, even for us, for our brain, for us to provide a list to you so that the list is maybe in the record, or Mr. Lee has the list.
I think that is a fantastic idea in school.
Okay,
So
great.
to the extent that you requested administrative notice, and put that, maybe you should keep that as a separate list that you ask us to upload to your folders, or let's keep a running tally of that. And please do, because while I don't want to put everything in the record, I do want the commissioners, advisors, Office of General Counsel to be able to access the document at their pretty quickly at their fingertips. So that's another excellent point. 2 gold stars this morning, Ms. Gould. Thank you.
Thank you.
It
Well, I
truly-
have
It truly are the better half. Just kidding, Mr. Gould.
He's at the dentist. I don't know what is
okay.
preferable.
I just probably literally or somehow struck a nerve.
No,
Okay.
I think he's
Um,
happy to be able to have me here. So I have one other issue, and hopefully I'll get 3 for O. This one might be, so speaking about making the hearing as streamlined as possible. Mr. Gould and myself have noticed the value of being able to do share screen, especially when Mr. Ryan was helping out Mr. Gould during his cross-examination. We have several documents that we are going to be going through with Mr. Casas and Ms. Chan and possibly Ms. Pitts, and it can get very confusing, especially because the schedules are so voluminous. And so my request, because Peter's not really, Mr. Gould's not really
As
equipped
conversant,
to do the share screen, my request is that during the cross-examination of Casas, Chan, and Pitts, that I be allowed to enter the Zoom room and do the share screen while he does his cross-examination.
request granted.
Thank you.
Thank you. And what Ms. Gould is referring to is ordinarily we only allow one counsel per party because of the multiplicity of Zoom panels that we're looking at here. Unless it's not, it's later in the day and we have 4 panels. But right now we have quite a few panels. I'm going to go to Ms. Regensburg, who has her hand up. Good morning, Ms. Regensburg.
Good morning, Hearing Examiner Medeiros. I just have one little housekeeping matter about our exhibits. We uploaded the exhibits that were on the docket, and I just realized that there are 2 copies of direct testimony for Mr. Malden and Ms. Ramey that we submitted errata on July 11th. So I would like to replace the exhibits that I uploaded for those 2 testimonies. And I just wondered, is the best way to do that to email copies to everybody?
Yes.
Okay.
Yes.
I just wanted to confirm. That's
Thank you.
Thank you. Mhm,
Yeah,
Thank you.
be sure to flag it for us though, because we're getting so many emails.
I understand. Thank you.
Thank you.
Mhm.
Mr. Albright.
Yes, sir, just to let you and Hearing Examiner Ryan and my colleagues know that, again, I have a commitment at some point today, so I do have cross-examination for a number, but not all of the scheduled witnesses. And just, again, once, if I am not able to participate at a particular time, I waive that cross-examination. So I just wanted to let people know that I may be in and out. I do have previously committed commitments today. So thank you very much.
Thank you, Mr. Albright. In fact, that happened yesterday afternoon.
Yes, sir. Notice that, and that's fine.
Okay. Thank you, sir. Mr. Williger, good morning again.
Good morning again. So I just want to, update you on hearing exhibit bench request 1, which is the bill impact for the San Juan rate credit.
Which we're not talking about in the case for now, by the way. Right?
Right. Right. So Dr. Pitts has spent a fair amount of time working on that this week, as you might imagine. My request is that in order to do the street lighting and private area lighting, that's rate 6 and rate 20 bill impact, that requires over 60 separate calculations. Typically, sometimes in our bill impact, we have not separately, it's been pretty standard practice that we haven't always separately calculated each street light rate. I'm wondering if we can get your express permission to not go through that exercise. We might be able to get it to you today. If we don't have to do that, she's got a few more rate schedules to go. But if we can't, we will definitely not have that until Monday if you want the street lighting rate impact. Street light and private area lighting rate impact. I'm sorry, bill impact.
Monday, I'd like a complete picture if possible. So Monday is fine. I'm
Okay.
sorry to put you through the running that, but
It's not me, it's Dr. Pitts. Okay, all right, we will do those. It just requires over 60 calculations because there's separate street lighting rates for everything.
well, is there a chat bot for that?
Is there a what?
Kidding.
Oh,
Hey.
no, I sorry. I haven't finished my coffee yet either. Hearing examiner, so apparently I should. No, I don't believe so. Especially Dr. Pitts has to do that work. All right.
Well, let me ask you this, then. Is it informative about all rate classes without running those 60 runs or calculations? Is
I
it
mean-
informative, the bench request response?
I think so. I mean, I don't know that anyone actually goes up for a specific high pressure sodium light for each light to look at their bill impact. You know, it's because then you'd have to total each one you have up. I don't know that even the city or county or whoever has streetlights would actually go through that exercise once we did the
And-
bill impact for each separate streetlight.
But that customer could ask you for that if there was a reason for that customer to ask you for it, right?
Absolutely.
Okay, so unless there's an objection, and I hopefully Ms. Pitts will, because I've asked her for a lot of things over the years too. So hopefully she'll remember this. She doesn't have to do those 60 calculations, then you can provide it later today, the response to bench request 1.
Okay.
Unless there is objection from the county or the city or, well, the city's waived participation in the hearing, but so Mr. Albright,
Yes, Mr. Hearing Examiner, and for the PNM info, if we need it, we can certainly make the request, but we have no objection to that.
great, okay, so we are not going to require those additional calculations. Thank you, Mr. Williger, very much for bringing that to our attention.
Thank you.
Is there anything else? Okay, Mr. Williger, I don't know, do we need to do we need to recall the witness, or can we just sort of move into asking questions of Mr. Cervantes?
PNM recalls Mr. Cervantes. Mr. Cervantes, you've been previously sworn. Is that correct?
Correct.
Okay, and that that swearing in yesterday applies today. I tender Mr. Cervantes for cross.
Thank you. Okay, Mr. Borman,
Yes, Mr. Hearing Examiner.
hope I didn't get you in too much trouble last night.
I was able to talk my way out of it, thanks.
All right, we have you for 20, is it, where are we here? 20 minutes,
I'm ready to proceed.
please do.
Thank you. Good morning, Mr. Cervantes.
Good morning.
Could you turn to page 10 of your direct testimony?
Sure. One moment, please. Okay, I'm there now.
Okay. And I think beginning on line 9, you say that customers who pay their PNM bill by credit card, debit card, or ACH via the website or IVR as a guest are assessed a $2 convenience fee per payment. Is that correct?
That is correct.
Okay. And you further note on the next page that customers paying by ACH when logged onto their account on the PNM website do not pay this charge. Right? Yeah. Okay. And then you state that the fee, the $2 fee, reflects a pass along from PNM for the charge imposed by the third-party bill payment provider. Is that all correct?
Yes,
Okay. So is it accurate to say that the charge the third party imposes on PNM for processing these electronic payments is exactly $2 per transaction?
it is.
Okay. And PNM's current practice is to pass along that exact charge to the customer causing that charge to be incurred, correct?
Correct.
Okay. And what PNM is proposing here is to remove this fee from the individual customer paying their monthly bill and instead recover these costs through base rates paid by all consumers, correct?
Correct.
All right. And that includes customers that don't take advantage of that service, right?
It does.
Now, despite this proposed change in how PNM recovers this cost, the charge that the third-party processor imposes on PNM will remain $2 per transaction. Is that right?
Under the proposed plan, no, we've actually, if implemented, the per transaction cost would be reduced. We've worked with the payment provider to renegotiate a lower cost.
What is that cost?
That cost is, give me one moment. I have that on one of my exhibits, I believe. One moment. Just 1 second. I'm trying to find the most recent estimate that we were provided. So if you turn to my exhibit MAC 2, page 3 of 12. I provide some tables with some costs and then projections for the fee-free credit card plan, and it's the 7th column on the top table. Per credit card transaction fee, it's $1.85. That's the renegotiated fee. Again, these cost proposals were provided to us by the payment provider last year when we filed. There is a potential that cost may change just based on, changes in the economy and inflation. So we would need to visit with the payment provider to see if these payments still, or the costs still, are still valid.
Okay, and to make sure that the record is clear, first of all, this is your MAC 2 attached to your draft testament, correct?
Correct.
Okay. And I see the per credit card transaction fee column appears to be $1.85, right?
Yes.
And that reflects a small reduction in the charge that the payment processor will be charging PNM, correct?
Correct. And one thing I do want to note is that under the current model, the $2 fees that the customers pay today, the customers that pay using a credit card, that includes a cost to subsidize the free ACH payment option for those that choose to pay for free using the ACH option online.
Okay.
So that cost is included in there as well.
So
Do
is
you
that
have an estimate of that cost, the subsidization?
Yeah, so I believe today that cost is about 20 cents, but I would have to, confirm that with the payment provider to get those.
well, in looking at this, if I may continue.
Yes.
Mr. Borman, I hope you didn't mind the interruption. Apologies. Go ahead.
No worries. I just want to know if you're
I'm
complete.
dead.
Okay. Looking at this exhibit, would that be the next column, the fee to continue covering free ACH?
Yes, that's the next column, and that's also, included in the total amount that we that we've estimated the total program would cost. And that's again, assuming that the transactions would kind of remain at the same level that we're seeing today.
Okay, and is that 16-cent charge for the fee to continue covering free ACH? Is that less than the current charge?
I'm sorry, is that,
Less than.
thank you.
Yeah, I would have to confirm what that current charge is and what the $2 is subsidizing, but I believe it is.
Okay,
And this would also cover free ACH via the automated phone system, which again, today there is a charge.
thank you. Now, could you?
Borman, can I just confirm if Mr. Medeiros, if you just pause, Mr. Borman, I just want to make sure I understand what Mr. Cervantes just said, just to confirm I'm on the same page. So if I understand what you've told Mr. Borman is, if the commission approves the fee-free program, then the provider of the services, the clearing, what is the name of the clearing company that utilize? I don't know if that's the correct term, but the company that you pay, the PNM pays for these services, who are they?
So the payment provider is Kubra, is the name of the company. Yeah.
Okay, so
Can you spell that?
It's KU, B as in boy, R as in Robert, A as in Apple.
And so what they've agreed to is if, and I'm just going to sort of say this in a summary fashion, but you can correct me if I'm speaking inaccurately. If the commission approves that and the costs, this fee-free program goes into place, they've agreed to charge customers less for all these services. Is that right?
Correct.
Why?
Because we are anticipating that the volumes will go up for payment transactions, in this case, credit card payment transactions. So, just the volume is something that they're considering in their pricing model that they've provided.
What would they call that, uptake?
Yes.
Or more revenue?
And then I think another point with what you just said, which I think actually is rather significant. So again, I just want to, for clarity of the record, the people who are now free ACH payers, like my wife, for instance, she takes advantage of that process. She gets that free service, not for free, but because other people are carrying her.
Correct. And specifically the customers that pay the credit card fees and ACH fees via the IVR when it's not offered for free.
Well, let's make, wait.
Yeah.
Here, Examiner Ryan, let's make, since we're talking about wives who both do this, let's make sure we're talking about the same service. Are you talking about, Mr. Cervantes, when we're talking about the ACH, and I'm sorry, you probably said this yesterday, but is it the folks who enter their checking account numbers?
Yes, so it's folks
and
that
that's being subsidized.
And that's being subsidized by those that are paying a $2 fee. Correct.
And what's the thought with that? Like, why? I mean, is there some principle underlying that idea?
When we first negotiated the payment, this payment service back in, I believe it was 2013, 2014, I had to go back and look at my records. That was one of the approaches that we determined was appropriate. The payment provider was able to provide this payment or pricing model that would both allow for a lower payment fee when you look at what we were charging previously. I think previously the per transaction fee for customers was $3. So we, when we moved over to Kubra, again, I think this was back in 2013, 2014. Again, I would have to confirm. We renegotiated by engaging with Kubra a lower per transaction fee for customers paying via credit card and debit card. And as part of that, there was the option for customers to pay for free via ACH. And, this was a kind of an approach that we agreed on to ensure that we continued with that option of offering customers a free ACH option.
Follow-up question I have to ask is, should the commission be concerned? So to contextualize this, yesterday afternoon, right before we concluded proceedings after the 5 o'clock, many folks had left at that time because some had other things to do. Effectively what we showed, and you can correct this if I'm misspeaking, is lower income people tend to utilize the credit card service. Is that a basic statement? Is that a correct statement?
That is correct, based on the data that we analyzed.
So should the commission, if that's the case, should then the commission be concerned that lower income people are subsidizing ratepayers who have ACH usage, who theoretically are of greater income, so socioeconomic status? Is that a concern the commission should have?
Well, I believe that, under the existing model, again, based on the information that we have, that is a concern, yes. Again, based on the information that we have, about close to half of customers that pay using a credit card today are low-income customers. Again, we were able, when we moved to KUBRA back in 2013, 2014, we were able to renegotiate the that per transaction fee to a lower fee. So, we did see some benefit there for customers. But again, I think we would need to consider also who is using the free ACH option, which, it is quite possible that there are low-income customers utilizing that option as well.
But isn't it? Yeah, well, okay, I think I know what you're going to say, Mr. Medeiros. To say it's free is not an accurate statement.
Nothing's free.
That was the other thing we talked about yesterday. So the free ACH only exists as a free thing because those folks with credit card payments who eat the service fee are carrying the ACH users. If that's not correct, you can say, no, that's wrong, but that's my understanding what you're saying.
That is accurate.
And Mr. Cervantes, Mr. Hearing Examiner Ryan, can I?
Yeah.
Jump in here too. We asked you for information. I don't know if you're going to be able to obtain it by block, the data for the different users of these services. And I understand we're talking about 1A, 1B, and 2A, right? Or
2A and 2B.
2A and 2A. Are you able to obtain that information?
So we're looking into it. That may be difficult information to obtain because of the movement between blocks that exist among customers, right?
Right, because some months, some customers aren't. Any data that you can find there, because are there other data in the case? Are there other data in the case that think up somehow or correlate the blocks in that particularly residential customers are in with income status? Or in other words, are higher consumers of electricity correlated with higher incomes in New Mexico? They can afford to spend more on electricity, to be blunt.
Yes, so I believe, and Mrs. Pitts will probably cover this in her portion of the testimony, but there is some analysis on block distribution among low-income customers and non-low-income customers.
Right.
And that distribution is pretty even when you look at low-income customers. It's about when we look at the months where there's some pretty high consistent usage, which would be July, your summer months, and then January, your winter months. In the analysis that Mrs. Pitts has done, about close to 30% of low-income customers are hitting that block 3.
I know. Go ahead.
Yes, go ahead. Sorry.
No, you please go ahead.
Yeah, so I was saying, so that's information that's that we provided.
Okay, and I've looked at it. I just didn't know precisely. I couldn't remember right now. Can you hear me?
Yes.
Okay. I know that's where it is. I didn't want to go try and pull it up, but I'm just wondering whether there's some subsidy going from better, more well-off customers in the system to those that have to rely on a credit card or a debit card to make their payments who are lower income. So if there's any way of teasing that out or representing that in a bench request. But I'm going to stop talking because Mr. Aguilera has a question. So I'm going to just stop talking right now. Go ahead.
Thank
Good
you.
morning, Commissioner.
Good morning. I was just reacting to sort of the notion that the low income customers would be subsidizing those who are not low income, because I seem to recall that the percentage that we discussed yesterday of low income consumers using a credit card was like 45%. So it was less than half. So I guess, Mr. Cervantes, wouldn't we need to know also what that same percentage for non-low income consumers to be able to compare it and determine which way the subsidy is going?
In terms of the, who's making a payment via credit cards or, that are being assessed the fee, what that kind of the breakdown is of
Yes.
low income versus non-low income?
Yes.
Yes, so I think we can say that the remainder, so 55% in this case, would be considered non-low income customers that are utilizing the credit card.
Okay, so more non-low income customers are using the credit card.
Correct.
And and the credit card users are the ones paying the subsidy. Is that correct, since they're paying a higher fee?
For the free ACH, correct, yes.
Okay. Yeah, I think that information that we discussed yesterday, if it could be broken down into the blocks, block 1, block 2, block 3, I think that would be very informative to be able to evaluate this proposal.
Okay. Yes, we're looking into it and doing our best to obtain it.
Thank you.
Anything else? I'm sorry.
No,
You're welcome.
I was just saying, yeah, thank you.
Hearing Examiner Ryan, anything else?
Nothing further. Back to Mr.
Okay.
Mormon.
Right, starting it back up, the clock that is.
Thank you. Mr. Cervantes, I think you said that Kubra was the payment processor that PNM currently uses.
Yes.
How long has Kubra been in that role? How long have they been the payment processor?
I believe that we partnered with them in 2014 14, Mr. Borman, I would have to just confirm the date, but it's been some years.
Okay, so it's been a while at least, correct?
Yes.
Okay, has PNM put this third-party payment processing service out for bid since that time?
We have not. No, we haven't. Not so far.
Okay. All right. If you could turn to page 11 of your direct testimony.
Yes.
I gotta turn there too. Are you there?
I am.
Okay, I think in here you say that approximately 14% of customer payments in 2021 were made by credit card or bank card or by ACH as a guest. Would you agree with that?
So you said page 11, Mr. Borman?
Page 11, I think it starts on line 13.
13. Yes, it's so it says in 2021, PNM customers made a total
I'm
of
sorry, sir, if you could slow down and start again. Yes, it says,
in 2021, PNM customers made a total of 5,559,747,000 payments, and 12.8% of these were made via credit or debit card.
And with an additional 1.12% being made by ACH as a guest, is that correct?
Correct.
Okay, so that's about 14%, right?
Correct.
Okay. Do you first of all, do you have that number for 2022?
I don't have it in front of me, but I can get that number.
Okay, and now maybe some of the information I'm going to ask, if this is included in the bench request or the response to the bench request that you're going to provide, I understand, and you can just say that. But what percentage of customer payments in 2021 were made by ACH while logged into the account PNM website?
So that is information that we're including in the bench request.
Okay, I understand. Now, did PNM perform any study to determine how many customers who currently pay via ACH while logged into their account will change to paying by credit card or debit card?
We didn't in terms of technically we included some of those questions on the surveys that we performed in 2021 in terms of just payment preferences. So that helped us basically determine what type of engagement we would see if these options, would be offered for free. And so if you look at the surveys in my exhibit on my testimony, I provide some of that information, and I'm sorry, it wasn't my rebuttal testimony. I did provide the responses to the surveys. So we did look at that information, and based on what customers shared in terms of their preferences of how they want to pay, we determined that the ACH customers that prefer to pay via ACH will pretty much continue with that, with that same preference.
Okay. And I guess I'll try to make this simpler, because paying ACH while logged into the account, that's basically taking advantage of the current free payment process, correct?
Correct.
Okay. So I guess what I'm trying to find out is how many customers that currently take advantage of the free electronic payment process will change to the new free payment process if this program is adopted. And I guess I'm asking if you don't have any numbers to support how many would change?
Again, not I think to maybe the level of detail that you're asking for. We based, again, our projections on adoption of the fee-free credit card option, based on what what other utilities have experienced in other jurisdictions, utilities that have implemented similar programs. And that's how we kind of came up with that. But we don't really kind of have a projection to determine of those paying via ACH today for free, what percentage of those will move to, a free credit card payment option.
Okay. And is it correct that the eSource article that you include as your exhibit MAC3, your direct testimony, that doesn't really address such situations either, does it?
It does not.
Okay. Well, let's turn to that exhibit MAC3 if we could.
Okay. One moment.
And yeah, it'll take me a second to get there as well. And I'm looking at page 9 of 15.
Give me one moment. You said 9 of 15, correct?
9 of 15.
Okay.
Okay. Now, towards the bottom half of that page, the report notes that their 2019 website review shows that if utilities use third-party vendors, they are more likely to charge bank card fees. Is that correct?
Let's see. Are you looking at the table at the bottom?
Well, I think I'm looking at figure 4, but the little text right underneath there. And I think even quite above, there's the section where what role do vendors have? Do you see that?
I see that.
Okay. And that's what it says, right? I characterize it correctly.
So as you see that, we one moment while you review that. Correct.
Okay. And it follows that utilities who don't use third-party payment vendors would be less likely to charge fees. Is that right?
Correct. That's what it states.
Okay. So, and it looks like that figure 4 shows a significant difference in the percentage of utilities charging a fee between those who utilize the third-party vendors and those who do not. Would you agree with that?
One moment. Correct.
Okay. All right, now let's turn back to your direct testimony, the textual part, page 14. And again, both of us will take a few minutes to get there.
Okay.
You there?
I am there.
Okay. Starting on line 17, I think you state that digital payments are expected to continue growth at an expansion rate of 14.86%. Is that right?
Correct.
That's an annual growth rate, right?
Right.
Okay. An annual growth rate of 14.86% would correspond approximately to a quarterly growth rate of 3.7%. Is that correct?
Correct. And this is specifically talking about digital payments, not credit card payments.
Okay.
But I'm not sure that we can really focus this statement on just credit cards. This is just kind of giving a holistic picture of digital payment preference that customers have.
Okay. But in doing your analysis, and I think you say this on page 12, you assume that PNM's credit card payments will increase by 25% per quarter, but then level off in year 2. Is that correct?
Correct.
Okay. Well, let's stay on page, I think this is page 14. You discuss the results of this. Well, let me ask you this. I'm not sure if it's on page 14. Oh, yes, it is. Page 14, line 8. PNM customer surveys conducted in April 2022 indicate 33% of residential customers and 37% of small and medium-sized businesses prefer digital payment methods. You see that?
Yes.
How many respondents did PNM receive to that survey?
There were 410 responses, and there were about 15,000 surveys that were sent out. So that 410 number did provide a 95% confidence level that that the responses are representative of the of that group.
Okay. And finally, you also, part of your proposal is to raise the cap for larger customers to $25,000 per payment with a 3% service fee. Is that correct?
Correct.
Okay. How did PNM determine whether or not that cap and fee were appropriate for such customers?
We did look at the payment or bill amounts, I guess, from the various customer classes, and determine that for larger customers, a $25,000 cap would be more suitable to their needs, based on, again, the larger bill amounts that they carry.
You say more suitable to their needs. How did you make that? How did you reach that conclusion?
Again, based on the fact that they have larger bills to pay. So, for the most part, customers in those other rate classes that are not included in this fee-free payment model that we're proposing would be able to utilize the service if they wish to.
Okay, thank you very much, Mr. Cervantes. I have no further questions for him.
Thank you, Mr. Borman. Mr. Williger?
Yeah, just a few follow-up questions. Mr. Cervantes, you were asked some questions from Mr. Borman about utilities who do not use a third-party payment vendor. Do you recall those?
Yes.
If PNM did not use a third-party payment vendor, I assume the payment requirements would have to be brought in-house. Would you agree with that?
Correct.
And that would cost money to bring those services in-house. Would you agree or not?
It would.
And that would that be recovered through rates likely or not?
I believe it would be recovered through rates likely, yes. And there's other implications too by bringing in, a payment or the payment functions in-house. One big one is, being having to be PCI compliant. That brings a lot of implications in-house in terms of, ensuring that that's the case. It just requires a lot of resources and technology and all sorts of things that, we're not payment providers ourselves, which is why we rely on companies like Kubra that have been doing this for years and, have established processes, technologies, and measures to ensure that, they are compliant.
Okay, thank you. One other question. You were asked some questions by Mr. Borman about if if PNM had done a survey of how many customers who are currently paying via ACH on the pnm.com website when they're logged in would switch to a credit card payment. Do you recall that?
Yes.
Did you state, or just for clarity, or do you know, what if do you expect customers who are currently paying via ACH by being logged into pnm.com will continue to use that service and not switch to credit card? Do you know?
Yeah. Our, again, just based on the customer input that we've received, our projection is that customers will continue to use it's all a matter of preference. So customers that prefer to pay via ACH, we believe will continue to pay via ACH. And there are customers who are paying via credit card. Those customers have expressed, some significant dissatisfaction towards the fact that they're being assessed a fee. They'll likely continue to pay, but they will continue to be dissatisfied. And there's a number of customers that would like to pay via credit card, but instead choose other means of payment, like going to a payment center or, maybe mailing in their check to avoid the fee. So, yes, I think that maybe answers your question.
Okay, thank you, hearing examiner. That's all my redirect.
Mr. Medeiros, I actually have a question, and I want to ask Mr. Cervantes before he goes.
Please go ahead. By the way, I did ask Commissioner Aguilera if he has any further questions. So
yeah, Commissioner Aguilera, you can go first if you wish.
Sure, thank you. So Mr. Cervantes, I would like to ask, well, rather re-ask a question I asked yesterday, because I may not have phrased it properly and wanted to give you another opportunity to respond so that I'm sure that I understand. And my question is, in crafting this proposal for your fee-free program, did PNM consider the interests of its low-income consumers? And if so, how are those interests reflected in your proposal? And do they benefit your low-income consumers?
I believe that we did, and that was one of the big reasons of why we designed this plan and proposed this plan, because as I mentioned earlier, there is a pretty significant number of customers that are low income today that are relying on a credit card to make a payment, and so they're incurring that $2 fee, which in their situation represents a bigger burden than a non-low income customer. And so that this was a way for us to address that, is to eliminate that fee and bring those fees into rates. And then the other part of the proposal that's also included here is the in-person payments, and making those free of charge at the various retail locations that are available through Western Union. So to kind of put this into maybe a little more context, when we looked at the information, about 65% of customers that paid via those in-person payments are low income, and a lot of them are going through great lengths to go to a location that's free or a PNM payment center just to avoid that fee. But there are some that are still paying the fee at the payment centers that do charge a $1 fee. And I want to be specific that it's the Western Union locations that include that $1 fee. So I think in overall, when we looked at this issue, low-income customers were considered, and I believe that implementing this model would be beneficial to them in the long run for those reasons that I described.
Thank you for that response. So one thing that I'm considering is, what does this do to rates in the future? What do you think is the risk of the third-party provider increasing its rates? What does your contract with KUBRA look like, and when can KUBRA increase its rates? Can you speak to that?
So I don't have, I think, the information to speak to, the possibility of those rates in terms of the payment costs that the payment provider has provided, those increasing in the future. I don't have that information, but in the, during the years that we've been a partner with them, there has not been an increase. And it's been, again, I want to say at least 6 years, if not, again, more. I have to go back and look at my records. So, there's always a possibility, right? But I don't believe that it's, that I can truly speak to with certainty what that possibility is and what those rates might look like in the future. We would need to have some, conversations with the vendor to get a better picture of what we can expect.
Okay. Thank you. And then
You're welcome.
Finally, so you've presented some information from EEI. So thank you for looking at best practices. I think that's a great place to start. Does that documentation explain other potential approaches? Maybe more innovative solutions that, or some that might be more beneficial to low-income consumers. Were there other approaches discussed in that, or is this, free for every? And I know this doesn't apply to every rate class, but this applies to residential. So that's sort of, my questions are sort of, that's where they're coming from. Did you consider other approaches within the residential class?
We did. We looked at a couple of different approaches, and it really, they really focused on the rate classes versus income levels. So, we looked at, for example, what would it cost for all customers to have access to those fee-free payment options, right? Including larger customers. And that in the long run would.
Oh, I think I lost audio.
Have been, would having disproportionate impacts on. Can you hear me?
I can now. Okay.
Yeah. So we looked at, again, that as an option. It wasn't, beneficial for, for customers. It would have been more impactful, I believe, to residential and small business customers if we were to include everyone, including, again, those larger customers. We also looked at only doing residential, but that would leave out your small business customers who also rely on, a credit card for, their businesses. And it would have been, an impact to them. And, to answer your question on that EEI report, the focus is mainly on a fee-free payment model. There's really not much discussion, and it's the same thing with the other research that we've done. The focus has really been on, again, elimination of the fees, and then bringing those fees into rates, and spreading those rates across the customers. That's really been the focus, that I've researched and that my team has researched as part of this proposal.
Okay, thank you. Yeah, so that response was sort of about across rate classes, and I was wondering whether you had evaluated anything within the 1A rate. So basically within the residential class, a different breakup. I'm just thinking out loud. For example, credit card charges for block 3, when consumers reach block 3, or anything like that. Was anything like that considered?
No, not as part of this proposal. Again, we focus primarily on making it a simple kind of process for customers that again have expressed dissatisfaction towards against those fees. So that wasn't done. I think what our focus was really to treat this as another as other payment options that we offer today are treated in kind of the cost of service. So like our payment centers and even paying by check, right? That there's a cost attached to that to customers in rates. But everybody is able to pay for free via a check, right? So that was kind of our approach to this, was to kind of treat this as all other payment options in again, that cost of service model.
Okay. Okay, thank you. And just to clarify my on the spot idea, because I don't remember exactly what I said. I was thinking applying the fee to like block 3, but not applying it to, well, especially block 1. Well, thank you for your responses, hearing examiners. That's all I have, and I actually need to drop off. So I appreciate your time, Mulvey. Thank you.
Very good, and I'll make this quick, Mr. Cervantes. We have to move on to and get to other witnesses, but I know you've proposed here 10 FTEs, and that funds specifically additional customer service reps. Is that right?
That is correct.
Now, it occurred to me as we were having the discussion, what is a customer of PNM is itself a dynamic thing these days, right? So we're going to have a time of day pilot. We're going to have a whole home EV program. Being a customer is an active thing, and it will become more so to the extent to which we get into load shifting and try to incentivize customers to manage their energy in a way they haven't before. And so my question to you is, I know, for instance, Ms. Pitts talked about requiring $1.5 million for the time of day program to administer that, the pilot anyway. And I'm familiar with the grid mod program because I was the hearing examiner there. And I know there's also requests for funding in the transportation electrification area about how do you help customers understand the programs. I just want to know, do you deal with any of that? Or are you really just limited to billing and receiving payment?
No, I directly deal with that as well, supporting those programs.
Okay, so some of this money. So I mean, I guess what I want to know is, if a customer wants to know, hey, how I want to be part of the time of day thing, they can call, and your people will assist with that.
Yes.
Okay, so and I guess where I'm really going with all this is the money that you're requesting here for more full-time employees. This isn't sort of a silo of one specific need. That this would go towards the varying programs that PNM's offering customers.
Well, I want to clarify the amounts that we've in the costs that we included in my testimony for the 10 FTE in the contact center are only to deal with the existing demands that we have in the contact center, which currently, as you stated, we're not there yet with a lot of these programs. You know, time of day is not up and running. Grid mod is not up and running. So that's future state type of programs and strategies that will have an impact to the contact center. Those impacts are addressed in those separate cases and proposals. This, what I have in my testimony specific to those 10 FTE is to be able to handle the existing demands and the existing need in the contact center, and in turn to be able to provide customers with the level of service that they expect from us. You know, and that means timely response to their requests, timely response to their calls is ensuring that those are appropriate, you know, based on those expectations. And you're right. I mean, customers' expectations are changing constantly, right? I mean, customers are looking for quicker, easier, more real-time solutions. And that's again one of the big drivers for this fee-free credit card proposal that we've put in front of the commission, is that customers are looking for options. They're looking for ease of use. They're looking for us to be able to provide them with the solutions that other companies provide them in other in other businesses that they conduct. So it's again all about customer choice and what the customer is demanding, and we're responding to that.
Okay, thank you very much. I understand your answer.
You're welcome.
Any other follow-up, Mr. Williger?
No, thank you. Thank you for asking.
Thank you. Mr. Cervantes, thank you so much for your testimony and for your cooperation and working on these pretty complex issues, all things being considered.
You're welcome. Thank you.
And we look forward to the company's response to bench request number 5. And with that, I'll wish you a good weekend, and you are excused. Take care.
Thank you.
Thank you, sir. Bye-bye. Mr. Williger, are you up with the next witness? Or no?
No,
Apparently
you
not.
have Mr. Alvitris for the next couple, so.
Okay.
Yes, if you'll
All
give
right.
us a couple of moments, we'll switch out. I don't know if you want to take a break now, Mr. Hearing Examiner, or
Let's take 5 minutes.
5 minutes. Okay.
5. Be back at around 10:17 or 10:18. Thank you.
Mr. Alvedras, who's the next witness, if you don't mind telling me?
Adrian McKenzie.
Thank you.
That was about the fastest 5 minutes.
Walmart 10.
Mr. Maderos, before
We are
this
not on the record.
We're not. Ms. Gould, go ahead.
I just wanted to move some time around. I don't know if that should happen on the record.
And I just wanted to let you know that New Mexico area cross-examination 42 is now in your Dropbox folder. If you'd like to check to make sure.
Sure, great, thank you.
But let's move some time around. Go ahead.
I currently have 15 minutes reserved for Mr. McKenzie. I don't think I'm going to need all that time. If I could move 8 of those minutes to Mr. Gray, which would leave me 7 for Mr. McKenzie and 38 for Gray.
37
I would.
or
ask to
38.
move-
Yes, 38, right?
Great, thank you. I appreciate that.
Okay, sure. Anybody else? Okay, we're back on the record.
And if you're ready,
Yes,
PNM calls its next witness, Adrian McKenzie, and asks that he be sworn.
Mr. McKenzie, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter of opinion to be the truth, the whole truth, nothing but the truth.
Yes, I do.
Thank you, sir.
Mr. McKenzie, would you please state your name, your place of employment, and your job title?
My name is Adrian McKenzie. The last name is spelled McKenzie. And my place of employment is FinCap Inc., and I'm a principal in that firm.
Thank you. And did you prepare direct testimony dated December 5th, 2022, which has been pre-filed in this case?
Yes, I did.
And can you confirm that what we have marked as PNM Exhibit 11 is a true and correct copy of your direct testimony?
Yes, sir.
And is your direct testimony true and correct to the best of your knowledge and belief?
Yes, it is.
Mr. Hearing Examiner, we move the admission of PNM Exhibit 11 into evidence.
any objection? PNM Exhibit 11 is admitted, having heard no objections.
And moving on, did you also prepare rebuttal testimony dated July 28th, 2023 that was pre-filed in this case?
Yes, I did.
And can you confirm that PNM Exhibit 12 is a true and correct copy of your rebuttal testimony in this case?
Yes, sir, I can.
And is your testimony true and correct to the best of your knowledge and belief as set forth in PNM Exhibit 12?
Yes, it is.
Mr. Hearing Examiner, we move the admission of PNM Exhibit 12 into evidence.
Any objection? Hearing none, PNM Exhibit 12 is admitted as well.
And Mr. McKenzie is ready for examination.
Great, thank you. And starting with the cross-examination of Mr. Albright, I believe you have 28 minutes dedicated to this witness. Is that right?
That is correct. If I need to shift some from another witness later to complete it, I will request to do so.
All right, please begin.
Thank you, sir. Good morning, Mr. McKenzie. How are you this morning?
I'm well, Mr. Albright. Thank you.
I am Jeff Albright of J. Albright Law LLC, and I represent Bernalillo County in this proceeding. I'd like to start off with some questions regarding your direct testimony. That would be PNM Exhibit 11. And specifically, I'd like to start at page 3. and I'm looking at lines roughly 17 through 23, but continuing on to the next page, lines 1 and 2 on page 4. Are you there?
Yes,
And my question is, you state that you conclude that the cost of equity falls in the range of 10.0 to 11.3%. Do you see that at page 3?
yes.
Why did you exclude, what data informed you of selection of those as the minimum and the maximum?
That data is reflected on PNM Exhibit AMM-3, which is a summary of the results of my various analyses.
Well, and the question is, why did you ignore any data that was below your minimum?
Well, I didn't ignore that data, sir. It factored into developing the range, just as there's estimates that were above the upper end of the range, there's some that are below. So the range considers the various results, giving less weight to the extremes, as I say in my testimony.
But it looked like you only considered between the range of 10.0 to 11.3. Is that correct? Or am I misreading your testimony?
My final recommendation is 10 to 11.3, but I considered all of the results from my analysis in arriving at that range.
And you considered ranges below the 10.0, is that correct?
Yes.
And you recommend 10.25%, correct?
The company is requesting 10.25%, and I support that as a reasonable outcome, yes.
What was the basis on page 4? What was your basis for saying it is in my opinion, and I'm at lines 3, saying it is in my opinion that 10.25 understates investors' required return for the company?
The basis for that conclusion is that the 10.25% falls below the midpoint of my recommended range of 10 to 11.3%. So on that basis, I believe it's understated.
But you aren't referring to specific investor opinions with regard to that. Is that correct?
No, I don't believe that is correct, in the sense that my analyses, which underlie the recommended range of 10 to 11.3, reflect capital market data, which essentially includes the opinions of investors. So to that extent, investors' opinions are directly supporting my recommended range, as well as my conclusion that 10.25% is a conservative estimate.
And how many investors does that include?
Well, that certainly doesn't include a specific catalog of investors. There's none of the witnesses in this case survey individual investors as the basis for the recommendations. So we're looking at broad capital market indicators, stock prices, growth rates, beta values, bond yields as the basis of the determined ROE range.
I'd like you to turn to page 5 of your direct testimony.
I'm there.
And at the bottom, there's a question at lines 17 and 18 or thereabouts. Where does PNM obtain the capital used to finance its investment in utility plant? Do you see that question?
Yes, sir.
Okay, and one of the comments that you make is that since PNMR or PNM is a subsidiary of PNMR, that the common stock that's traded under the PNM is actually PNMR of the parent company. Is that a correct statement?
Yes.
Okay. You also say, in addition to capital supplied by PNM also issues debt securities directly under its own name. Do you see that?
Yes.
And how much debt, do you have any idea as to how much debt that is?
No, I don't off the top of my head.
Do you know who would?
I imagine Ms. Grinnell would know that number.
Okay. Turning to page 6, again, of your direct testimony. Don't want a lengthy detail, but just very briefly, at lines 9 and 10, you talk about elevated capital spending is a key risk that would require access to financing in light of negative discretionary cash flow. Would you just explain briefly what negative discretionary cash flow is?
Well, basically that refers to a situation which is common in the utility industry where cash flows from operations are not sufficient to cover the capital needs of the utility when it's undergoing a major capital expansion plan. So in order to meet those capital needs, the utility has to access external funding. So again, just the operating cash flows are insufficient to meet the needs.
Let's
Thank you.
And you're aware that the county's expert, Ms. Maureen Reno, provided a recommended ROE, correct?
Yes.
And would you also agree that for 2022, that PNM earned over its allowed ROE?
That's true. Under Rider 36, it had to give some of that money back. It's also true that over the last 5 years, PNM under-earned in 3 of them.
So two out of the 5 were over earned, correct?
Right, and the majority were under-earned.
Did you look at recent ROEs that have been approved by this commission in coming up with your recommended ROE?
No, that wasn't the basis upon which I derived my recommended range.
Do you think that's a relevant factor that should be included in determining comparable ROEs?
Well, allowed ROEs, both from this commission and from other jurisdictions, are certainly a benchmark, and I look at those in my rebuttal testimony. I think the commission needs to be mindful of the fact that we can't just look at historical data and make a direct comparison today given differences in capital costs. So I do cite to allowed returns from past cases at this commission as well as in others jurisdictions in support of my recommendation and support of the 1025.
And with regard to the determination, turning to the determination of the proxy group that you list, you have on pages 6 and 7, and specifically at 7, the question is asked, how do you identify the proxy group of electric utilities relied on for your analysis? Did I quote that correctly?
Yes, sir.
Page 7. And you identify 3 criteria, the following criteria to identify a proxy group of utilities, and you list 3 items. Do you see those 3 items?
I do.
Okay. The first says, included in the electric utility industry groups compiled by value line. 2 says paid common dividends over the last 6 months and have not announced a dividend cut since that time. And number 3, no ongoing involvement in a major merger or acquisition that would distort quantitative results. Have I quoted that directly? Correct?
Yes, sir.
Okay. Well, let me ask you a couple of questions. You've included in your group Emera for one, and they are not an electric utility. Is that correct?
No, that's not correct.
Are they? I thought that Emera is identified as not as an electric utility, that they're included as a power industry group. Is that
Yeah.
correct?
It is correct, as I indicate on page 7, that Value Line includes Emera in its power industry group. However, Emera is an electric and gas utility.
Can you spell Emera?
Yes, EMERA.
Thank you.
And in looking at the three criteria, it looks like the proxy group satisfies probably all three of those conditions, but isn't it true that item number 3, that PNM is involved in a major merger or acquisition that would distort quantitative results? So wouldn't that be a concern that you're comparing oranges and apples here?
No, I don't agree with that statement. PNM Resources is involved in a merger with Avangrid, which is obviously ongoing. And they were not included in my proxy group for that reason.
When you say they, what are you
PNM.
talking that, so you did not, so you're distinguishing between PNMR and PNM, but PNM is also involved in the merger and acquisition, correct?
Well, technically, I think it's PNMR that is involved in the merger and acquisition. Obviously, PNM would be acquired by Avangrid if the merger goes through. But for purposes of constructing a proxy group, the issue is mergers obviously can cause distortions. They can impact the stock prices and other data, but it's very difficult sometimes to know what expectations are underlying those stock price moves. And so in those types of circumstances, it's less reliable as a basis to estimate the cost of equity. So that's why I excluded PNMR from the proxy group.
What happens to the debt of PNM if a merger were to be approved?
I have no idea. I haven't examined that issue whatsoever in my testimony.
On page 11 of your testimony, you do talk about, the question is posed, would investors also consider the implications of regulatory mechanisms in evaluating the company's relative risks? And your answer is yes, and then you go through an explanation. Would you agree that more and more of the costs to consumers are being addressed through riders and through extra fees and costs rather than through a rate case?
Well, I don't know what you mean by extra fees and costs. I will agree with you that regulatory mechanisms have become increasingly prevalent throughout the industry over the last probably decade.
And don't you think it's more appropriate for those to be addressed in a rate case as opposed to individually added as riders to a customer's bill?
I don't have an opinion on that issue. I haven't included that as part of my testimony whatsoever.
Okay. So you do discuss it, you're direct at page 11, lines 11 to 12, and then continuing to 19, that in your that cost adjustment mechanisms like riders reduce regulatory business and financial risk by guaranteeing cost recovery. Is that a fair statement?
Can you point me to where you think I'm saying that? I
Yeah.
don't see that in my testimony.
I believe it is at page 11. And it begins at line 17, where you say, as a result, adjustment mechanisms, cost trackers, and future test years have become increasingly prevalent, along with alternatives to traditional rate making, such as formula rates and multi-year rate plans. Have I quoted that correctly?
Yes, and I agree with that.
Do you think that's fair for consumers not to be able to address it in a rate proceeding?
I'm sorry, I didn't understand the question. Not to be able to address what?
Those additional costs and fees that are, I'll say, external to a rate case proceeding. Shouldn't those be included in a rate case proceeding for the benefit of the consumers?
Again, my testimony, the purpose of my testimony wasn't to conduct a wide-ranging review of policies related to the application of regulatory mechanisms. I'm certainly pointing this out because I think it's an important part of an evaluation of overall risk. But as to a general question of how riders are administrated, I mean, clearly the commission still has jurisdiction over those. And I would imagine also has the ability to ensure that they are implemented in a way which protects consumers.
I'd like you to turn to page 29, pages 29 and 30, where you talk about the DCF model. And Mr. Lee, DCF, correct me if I'm wrong, Mr. McKenzie, but DCF should be for dividend cash flow analysis, I believe, correct?
Discounted.
Discounted.
Sorry.
Which pages, Mr. Albright?
29 and 30, just have a couple of questions that I wanted to address there.
I'm there.
Okay, on page 30, would you, let's go to page 30. And you quote from the Indiana Utility Regulatory Commission, reciting to a principle with regard to a recognized approach estimating the ROE. And you say that an anticipated price appreciation of the stock can vary wildly. Well, that doesn't apply to PNM though, correct? Because it's PNMR stock that's traded on the New York Stock Exchange. Is that correct?
Well, again, PNMR is not the focus of my evaluation in this case. It hasn't been included anywhere in my analysis.
At your direct testimony on page 55, you describe the results of your DCF analysis applied to a group of low-risk firms in the competitive sector. And would you please can you identify any commission decisions, New Mexico commission decisions in which the hearing examiner or commission conducted a similar analysis?
Can you repeat-
previously?
Could you repeat the question, sir? I'm sorry.
Sure. At 55 lines, basically 8 through 13, you describe the results of your DCF analysis applied to a group of low-risk firms in the competitive sector. Is that a fair statement?
I'm having a little trouble with the page reference. Page 55. Actually show my non-utility analysis starting on page 56. So I just want to get to your question, but I just want to make sure we don't mess up the record or that I'm in sync with you.
Well, I will, for the sake of time, I will move forward. And I'm not sure what the disconnect here is. I think it is actually, you're correct. I think it is actually page 56, not 55, and it's at lines 8 through 13. Where the results, it says, this section represents the results of my DCF analysis applied to a group of low-risk firms in the competitive sector, which I refer to as the, quote, non-utility group, unquote. So have I quoted that correctly, and do we have the right reference?
Yes, Mr. Albright.
All right, thank you for that. So are you aware of any instance in which the New Mexico Public Regulation Commission or hearing examiners have conducted a similar analysis of non-utility groups?
Well, I two observations on your question. First off, I don't believe the hearings examiners or the commission submit evidence in proceedings, so they wouldn't be likely to have developed such an analysis. And the second point I'll make is that, as I point out in my testimony, my recommended range did not rely directly on this analysis. It is a benchmark that I think is useful, but it doesn't underpin my recommendations.
And I'll rephrase my question to state whether the commission based its decision, or the hearing examiners, their recommended decision based upon non-utility groups. Are you aware of any?
I am not.
I'm sorry, sir. I didn't hear your answer.
I am not.
Can you identify any FERC?
I'm sorry, I still didn't hear the answer. He's freezing on my end. Did you say I am not, sir?
Yes.
Thank you.
Can you identify any FERC decisions, that's FERC, Mr. Lee, in which the administrative law judge or FERC conducted a similar analysis of non-utility groups, firms?
Again, FERC and administrative law judges at FERC don't routinely conduct analyses.
4 minutes, Mr. Albright.
Thank you. Or base their decisions on such?
Not directly, although in opinion number 569B, which was issued in a case involving the Midwest ISO ROE determinations, the commission noted that information regarding firms in the competitive sector could be useful as a benchmark.
I'd like to turn to your rebuttal testimony. And specifically on page 14. And in lines 6 through 12, you state that PNM is currently authorized an ROE of 9.575%. You see that?
Yes.
But despite the fact that interest rates and inflation have increased since 1600276-UT, which means the cost of equity has climbed. The opposing witnesses are arguing that PNM's ROE should be reduced. Such an outcome would defy common sense and violate accepted principles of finance. Do you see that?
Yes.
When you talk about the interest rates and inflation, over what period of time are you looking at?
Well, I discussed that in my testimony. If you look at page 9, for example, of my rebuttal testimony in PNM table AMM 1, I compare bond yields and inflation rates corresponding to that decision with prevailing yields and inflation rates in June of 2023. Bond yields have moved up since then, but that is the basis of the comparison that I'm making.
And bond yields a year ago would have been much less, correct?
A year ago, yes.
Are you aware of any commission relying upon the results of expected earnings approach when setting allowed ROE?
Yes.
And can you name them, please?
Well, I quote the North Carolina Commission in my testimony. That's one I'm aware of.
Any others?
No, I mean, I haven't done a research study to examine orders in all the jurisdictions across the states. I'm aware of a somewhat dated NARUC study from the 90s that identified comparable earnings methods, which the expected earnings falls under that umbrella as being one of the primary methods. My testimony also quotes S&P as recognizing that the approaches used to estimate the ROE fall into two buckets, kind of market-based approaches like the DCF and comparable earnings type approaches, of which the expected earnings is one.
But you didn't identify any recently allowed ROEs in your rebuttal testimony in support of your recommended ROE of 10.25%, correct? And I'm talking about New Mexico allowed ROEs.
I think I answered that question earlier, sir. I didn't base my recommendation on historic allowed ROEs from this commission or any other commission. I do examine past ROEs in light of changes in interest rates to demonstrate that the company's 10.25% request is reasonable.
Mr. Albright?
Mr. Hearing Examiner, I have no further questions for Mr. McKenzie.
Thank you, sir.
Thank you, Mr. McKenzie, for your answers.
Thank you.
Ms. Gould? 7 minutes.
Good morning. Can you hear me?
Yes, Ms. Gould, I can. Thank you.
My name is Kelly Gould. I represent New Mexico Affordable Reliable Energy Alliance, also known as NMAREA. So I just had a couple questions for you, and some of them are going to follow up on Mr. Albright's questions. When you were first talking with Mr. Albright, you stated that 10.25% ROE is a conservative request by PNM. Is that accurate?
Yes, it is.
And you support this ROE request, is that correct?
I do.
And you stated with Mr. Albright that you did not base this your support on the commission, on the ROEs that the commission has approved for other electric utilities in New Mexico, but you are aware of those ROEs. Is that accurate?
Yes, I mean, I'm not an expert on all of the past ROE decisions of this commission, but certainly I do reference them in my rebuttal testimony, for example.
Okay, I'm going to ask you a couple questions. If you don't know, then just say you don't know. Do you know the highest currently approved ROE for a New Mexico electric utility?
No, I don't.
And so then you wouldn't know the highest commission approved ROE for an electric utility in New Mexico in the past 5 years.
No, I don't know the answer to that question.
Okay. And do you know the highest ROE awarded to an electric utility in 2023 as a result of a general rate case?
Well, the highest one was actually awarded at the end of August, which is 1145 for Alaska Electric Light and Power. And that was based on a 10.45 ROE for a triple B proxy group. So that's not reflected in RRA's data yet because it was outside the scope of the second quarter publication. But that order issued, I believe, August 30th or 31st.
Okay, I'm going to share my screen. I have what's marked as NM Area Cross-Examination Exhibit 17. Let me see if I can do this accurately. Is everybody able to see that?
Yes, ma'am.
Yes.
And Mr. McKenzie, is this, as far as you know, NM Public Service Company of New Mexico's responses to NM Area's 17th set of interrogatories?
Yeah, I think I need to get a hard copy in front of me because that's way too small for me to read on the screen. So if you could just bear with me for a moment.
Sure, does this help at all?
Keep
Was someone-
expanding, Ms. Gould.
The hearing,
I think what I see is different than what you see. Is it zooming or is it not zooming?
it is zooming. It's much better.
Is this better or
That's-
keep on going?
I don't,
Stop. Probably gonna have to stop.
that's good.
Okay. So would you confirm that this is PNM's responses to NM Area's 17th set?
Yes.
Okay. I'm going to scroll down to interrogatory 7-11. Sorry to make you all seasick here. Okay, here, NM Area interrogatory 17-11. Are you the sponsor of this interrogatory?
Yes.
Okay, so I'm going to read this for the record. Do you know if this interrogatory was supplemented?
I don't believe so.
Okay. So the question is, please confirm or deny that an authorized ROE of 10.25% would be the highest ROE awarded to an electric utility in 2023. If the answer is anything other than the affirmative, please provide a detailed explanation and all sources supporting Mr. McKenzie's answer. And you responded, denied. Of the 11 authorized ROEs reported for 2023 by S&P Global Market
I'm
Intelligence.
sorry, of the 11 ROEs,
Reported for 2023 by S&P Global Market Intelligence in its July 31st, 2023 RRA Regulatory Focus Report. The highest is 10.35%. However, this was the result of a limited issue rider proceeding. Issuer proceeding, excuse me. The highest observation reported for a general rate case was 10%. Mr. McKenzie would note that in 2010, when average utility bond yields were slightly below current levels, the average allowed ROE for electric utilities was 10.29%. Did I read that correctly?
Yes.
And your testimony today here is different than what you answered on August 22nd, 2023 to interrogatory NM Area 17-11.
Yes, it is because I just became aware of that Alaska decision.
Yet PNM has not supplemented this response. Is that correct?
Not to my knowledge.
Okay, so other than what you testified here today, is the second highest observed highest ROE reported for a general rate case would be 10%?
The second highest.
Well, you said that there was something higher. You just testified today something different than this interrogatory. And here in this interrogatory, you say the
Yeah.
highest observation reported for a general rate case was 10%.
Yes, 10% and 10.45 are the two that I'm aware of.
Thank you. Mr. Hearing Examiner, I move for the admission of NM area cross-examination exhibit 17, interrogatory 17-11.
Is there any objection?
Mr. Hearing Examiner, just to clarify, the only part of this exhibit, because it's a number of pages,
Yeah.
that's being admitted is the question and answer to NM area 17-11.
That is correct. We will have to do what we did yesterday and take the other questions out of this exhibit and only have 17-11 with the cover page and the affirmation page.
Yes, no objection. Thank you.
And maintain the same numbering, Ms. Gould?
I
Or do you
can
want to make
number
it 43?
I can number it 43, if that makes sense to you, Mr. Hearing Examiner.
Does it make sense to you? That's
Yes,
the numbering convention we started yesterday when we talked about doing this.
yes, that makes
Yes.
sense to me.
Okay, thank you. So that one will be 43. So this particular NM area cross-examination exhibit 43 is provisionally admitted, subject to being provided in the proper form.
Thank you.
You're
That's all
welcome.
the cross I have. Thank you.
Thank you, Ms. Gould. All right, let's see, Mr. Herman. Are you there?
I'm here, Mr. Examiner.
I have you down for 40 minutes with Mr. McKenzie, is that right?
That's correct. And good news is I do not expect to use all of that 40 minutes.
Great. Go ahead and start using the minutes that you are going to use.
Good morning, Mr. McKenzie. How are you doing?
I'm well, Mr. Herman. Thank you.
Thank you. My name is Keith Herman, and I represent the Albuquerque Bernalillo County Water Utility Authority in this matter. I've got a few questions about your direct and rebuttal testimony. So let's start with your direct, which is PNM Exhibit 11, if you have that handy.
I do.
In drafting your direct, what specific New Mexico materials did you rely on?
Well, I certainly examined credit rating reports for the company, which obviously deal directly with New Mexico. Again, most of the analysis of the cost of equity is premised on a proxy group, which depends on broad-based capital market data for the group and is not tied specifically to New Mexico, because of course the issue is the cost of equity, which is determined in capital markets, which are certainly national, if not global. So that determination isn't really premised on a lot of New Mexico specific data.
Let me be a little more specific. What New Mexico Public Regulation Commission cases did you review in preparation?
I certainly I reviewed a number of orders of the commission throughout the course of preparing my direct and rebuttal testimony in this case. I'm not really sure. I haven't kind of cataloged those. So I'm a little bit, you caught me unawares in terms of providing you with a list, but I certainly have reviewed some of the orders of the commission.
I believe you referenced the most recent decision in the SPS case, correct?
Yes.
And El Paso Electric?
Yes, I do reference the outcome of those decisions in terms of the ROE determinations.
Do you comment on the process used by the commission to reach their outcomes?
No, not directly.
Do you have any opinion about whether or not you agree or disagree with the outcomes in either of those cases?
Well, no, I mean, the purpose of my testimony was not to examine, was not to take issue with any of the prior findings of this commission. It's really to use those findings in connection with changes in capital market conditions to demonstrate that they support the company's requested ROE now, given the increase in interest rates. So I haven't gone back and looked at the evidentiary records in prior cases and made any determinations of what I agree or disagree with in those cases.
While we're on the discussion of New Mexico specific cases, are you familiar with PNM's multiple dockets related to decoupling?
No, not directly.
What about the Avangrid merger? Are you familiar with that docket?
No, sir.
Can I direct you to a question starting at page 11 of your direct? Question starting at page 11, line 11.
Okay, I'm there.
You mention, starting at line 17, cost adjustment mechanisms, cost trackers, future test years, and alternatives to traditional rate making formula as as items that would affect companies' utility or relative risks, correct?
Yes.
I read those off of starting at line 17 through 20, just for the record. And then on the next page, you additionally mention decoupling mechanisms, and that's page 12, line 11. Correct?
Page 12, line 11. Yes, that's a quote from S&P Market Intelligence discussing the prevalence of decoupling mechanisms.
And as referenced here, how would you define decoupling?
Well, very broadly, it's a mechanism that basically insulates the company's revenues from changes in consumption. So it's a way to take away some uncertainty about revenues, especially in times of declining consumption, for instance, through conservation, those types of issues.
So would another way, you use the word remove uncertainties, would another way of saying that be remove risk?
Yes, it definitely lowers to a certain extent the risks associated with under earning.
And then moving on to page 13 at the bottom of that page, starting at line 16, you state that PNM isn't decoupled, so it's exposed to additional uncertainty and risk, correct?
Yeah, and again, I think in evaluating regulatory mechanisms, we're not doing it in a vacuum. It's with respect to the industry as a whole, or more specifically, in the case of evaluating an ROE, the proxy group that we're using.
So I'd like to direct you to your direct testimony exhibit AMM4. Let me know when you're there.
Okay, I'm there, Mr. Herman.
And AMM4 is an identification of utilities you used in your proxy group, correct?
Yes,
And in the middle column, you have a column for full and partial decoupling.
that's correct.
And going back to your definition of decoupling, could you tell us how you differentiated full versus partial decoupling?
Well, actually, I didn't make that determination. I based this on a compendium compiled by S&P Market Intelligence. So I'm looking at what a respected investment advisory company reports to investors. So I didn't make that determination myself. I based it on what's reported to investors in that publication.
So what exactly was the source of that information?
It's footnoted on page 3 of that exhibit. It's S&P Global Market Intelligence Adjustment Clauses, a state-by-state overview. So that's the same outfit that reports the historic allowed ROEs that are talked about in most of the witnesses' testimony in this case.
Okay. And you don't have a breakdown of the utilities ROEs based on whether or not they're full, partial, or not at all decoupled, do you?
Well, we could potentially try to do that. I mean, my rebuttal testimony does report the average allowed ROEs that Value Line lists for each of the companies in all of the proxy groups. As I point out, that average is about 9.7 across all the groups. But we could try to match that, but I haven't done that. But you could, if you look at PNM exhibit AMM3 rebuttal, I list the allowed returns that Value Line reports for each of the companies in the proxy group as another benchmark to show that the recommendations of the other parties are insufficient. So you could potentially match those up.
Okay. Well, thank you for that. So if I went to AMM3 rebuttal, I'd be able to possibly determine whether or not utilities that are fully decoupled or partially decoupled or not at all decoupled tend to have higher or lower ROEs.
You could try. I think in the world of ROE, there's many factors going on. So there's timing differences. They're within those allowed ROEs. So we don't know to the extent that interest rates were higher or lower when those ROEs were established. That would probably overwhelm issues about decoupling. Certainly in the past, decoupling was considered, I think, as a standalone item. But now that it's really kind of widely prevalent through the industry and it's incorporated into the proxy group analysis, there's not really many cases where it's a significant, or whether it's taken account of specifically in developing the allowed ROE, is my experience.
It's more of a global approach, depending on when the ROE was awarded and a multiple of other factors, correct?
Yes.
Well, thank you for that. I'd like to move on to your rebuttal testimony now. And you rebut ABCWA witness David Garrett, correct?
Yes.
And just for sake of clarity, my line of questioning is going to be about David Garrett's testimony and not Mark Garrett. So when I say Mr. Garrett, it'll be David, if that's clear to you.
Yes, sir.
So let's start somewhere easy. at line or at page 40, line 1, where you state you agree with Mr. Garrett's assessment. Correct?
Yes, his assessment, the quote is on page 39. I quote from his testimony.
Yeah, that you would rely on multiple models,
Yes,
and any too much reliance on any single model might, what's the word he uses? Contain a degree of imprecision.
correct.
So how many models are we talking about here? How many did you rely on versus how many did Mr. Garrett rely on?
Well, the models I relied on are presented in exhibit AMM 3 to my direct testimony. So broadly speaking, the DCF model, the capital asset pricing model, an empirical form of the capital asset pricing model, a utility risk premium approach, and the expected earnings approach. So those are the various financial models that I presented in my testimony.
So about 5 models you identified.
Right.
And for the record, could you say what DCF stands for?
Discounted cash flow.
And in the next question on page 40, you criticize Bernalillo County witness Maureen Reno for using the risk premium approach.
No, that's not correct. I think I criticize her for not using it.
Oh, okay. I'm sorry for that. So you would then agree that risk should be factored into calculating an ROE, correct?
Well, yes. I mean, risk is a primary determinant of the cost of equity. So it's basically a fundamental principle of finance that investors require a higher return for a higher risk investment. And vice versa.
Mhm. Now, I'm checking my notes, but you then attest that PNM is a higher risk due to risks from climate change, correct?
Excuse me, I didn't hear the last part of your question.
You attest that PNM is at higher risk due to climate change, impacts from climate change?
No, I don't think I make that assertion in my testimony.
Let me see if I can direct you to what I'm referring to. Starting at page 50 of your rebuttal, line 7. Where you state it is likely that utilities today face greater risk exposure related to increasingly severe weather, cyber and physical threats. I'll stop there. You go on and list several other factors. But the first one you mentioned is increasingly severe weather, and I read that as referring to climate change. Is that a correct assumption?
Yes, but that's not directed to an evaluation of PNM's risk relative to the industry. I think what I'm pointing out here is that there's a variety of challenges that utilities in general face. And this is in response to Ms. Reno's supposition that somehow the risks have reduced over time.
So would you say in a general sense that utilities risks have increased?
Well, that's certainly what's indicated by trends in credit ratings, for example. So we've gone from an industry that was a solid single A rating. As S&P recently observed, it's the first time that the industry has fallen into the triple B category. So that certainly is indicative of higher risk. As I point out in my testimony, beta values have increased significantly. That's another risk indicator that suggests that risks have increased.
And going to utility averages, the average metric, you believe that's an important metric to consider in awarding an ROE as well, correct?
I'm not sure what average metric you're referring to, Mr. Herman.
Do you have access to Mr. Monroy's rebuttal testimony?
1 minute. Oh, it's a big one.
Well, it's only page 6.
Oh, okay. It's just a big binder. Let's see, page 6.
Let me get you the exact line reference, but the question starting at page 5, actually line 15. Then he identifies return on equity at line 20 and states at page 6, lines 2 through 4, the proposed ROEs are inadequate and contrary when compared to the national average.
I'm sorry,
ROEs.
proposed ROEs.
Slow down, please.
Excuse me. These proposed ROEs are inadequate and contrary when compared to the national average ROEs as adjusted for current interest rates. And then he further states that PNM witness McKenzie will address the ROE issues.
Yes, I agree with that statement.
And then, sorry to have you bounce around between testimonies, but I believe at page 144 of your rebuttal, you are critical of ABCWA witness Garrett for his statement that he believes utilities generally require, or commissions have been awarding utilities higher ROEs.
Can you restate your question? Sorry, Mr. Herman.
I'm sorry, I don't know if I've asked a question, but in Mr. Garrett's testimony, he makes a statement that regulators generally tend to award higher ROEs than necessary, and you disagree with that statement, correct?
Yes.
In fact, at page 162 of your rebuttal, you agree with Walmart witness Chris that awarded ROEs is a reliable benchmark, correct?
Well, as I state, and I think it's very important to get this clear for the hearings examiners and the commission, that allowed ROEs are a benchmark, but, and it's a big but, we need to be mindful of the differences between present day capital costs and capital costs corresponding to when those decisions were issued. So to the extent that we have a situation as we do now where bond yields, for example, have increased on the order of 190 basis points since this utility's last rate proceeding, we can't make a direct comparison between that ROE and today.
So you're saying it's a moving target?
I'm saying that it's always a moving target. Capital markets are always changing. So that's a given. And the important part is in trying to apply the opportunity cost standards that are accepted under financial principles as well as regulatory principles. We have to make sure that we're not comparing apples and oranges. So we're not looking at an ROE of 9% set when interest rates were 3.5% and saying that's a benchmark for today when interest rates are 6%. That kind of logic doesn't work.
Lastly, I want to ask about your work for your company. Is it FinCap?
Yes, sir.
In your representation, do you generally only work for utilities?
That's generally true. Our firm has in the past worked for industrial consumer groups and municipal utilities, but generally my work has been on behalf of utility companies.
All right, that's all I have. Thank you.
Thank you, Mr. Herman.
Thank you, Mr. Herman. Okay, let's see if we can move along with the cross-examination of Mr. McKenzie. Up next, Mr. McKenzie, are you okay?
Yes, thank you, Your Honor.
All right, you don't need to take a quick break, or are you all right?
I'm great, thank you.
Oh, you're welcome. All right, up next is Walmart with 16 minutes. Ms. Barrett?
Thank you, hearing examiner. Good morning, Mr. McKenzie. My name's Jocelyn Barrett. I represent Walmart. I just have a couple of quick questions following up on Mr. Herman's cross. He had you go to page 162 of your rebuttal testimony in which you address Walmart witness Stephen Chris's direct testimony. I just wanted to ask you for clarification on a couple of terms you used.
Okay, I'm
page 162 at line 19, you state, while a downward biased ROE may provide the illusion of customer savings. Can you explain to me what you mean by the term downward biased?
What I mean is an ROE that is below the cost of equity.
Okay. And as Mr. Herman pointed out, you did agree with Mr. Chris that allowed ROEs provide one benchmark worthy of consideration.
I'm sorry, you broke up. That did agree with Mr. Chris that?
Allowed ROEs provide one benchmark worthy of consideration in the commission's evaluation. You did agree with Mr. Chris on that point, is that correct?
I agree, subject to the very crucial caveat that I also discussed with Mr. Herman, that we can't compare apples and oranges, and we need to adjust those prior ROEs to reflect the implications of current capital costs, which is what I've done in PNM Exhibit AMM-1 rebuttal, where I take historic average allowed ROEs and show what those values would imply today, given the higher interest rates that we're now dealing with.
Okay, thank you for that explanation. And just one last question, if you could scroll down to page 163 of your rebuttal testimony, starting at line 5. You state, if the utility is unable to offer a competitive ROE, existing shareholders will suffer a capital loss as investors take advantage of other more favorable opportunities and the utilities stock price would fall. Does that accurately reflect your testimony?
Yes.
How, in the context of this statement that you made, how would one determine whether PNM's proposed ROE is competitive?
Well, I think my testimony gives the commission that data. I mean, I think I've presented the commission with current analysis based on accepted financial models, as well as benchmarks based on allowed ROEs that are adjusted to account for interest rates. I've also compiled allowed ROEs for the companies in the proxy group to demonstrate that all of the ROE recommendations in this case fall below those levels. So I think all of that data together gives the commission the information it needs to make a finding that 10.25 is a reasonable ROE for this company.
And to what extent do you consider, oh, I'm sorry, I lost my place. To what extent do you consider the other allowed ROEs when determining whether this is competitive? How much of a role does that play?
Well, again, coming back to Mr. Chris's testimony, I agree with him that allowed ROEs do provide one benchmark, which is routinely referred to in the context of evaluating a fair ROE for a utility. So that's, I don't disagree with them there. And my testimony examines that same benchmark as a way to demonstrate that the conclusions that I've made based on my financial analysis are reasonable. So the primary basis for my recommended range and my conclusion that 10.25% is a reasonable cost of equity is the analyses that I conduct based on the various methodologies which I discussed with Mr. Herman. Now, the benchmarks using allowed ROEs confirm my conclusions, again, once having adjusted for changes in interest rates. So I don't rely on historic allowed ROEs as a primary method in which to estimate the cost of equity, but I think they can be used as a benchmark to evaluate the reasonableness of the alternative ROE proposals in this case. And I think my rebuttal testimony demonstrates pretty conclusively that the other witnesses fall far short of what the cost of equity is in today's market.
Thank you. My other questions were covered by the other interveners, so I have nothing further for you. Thank you very much for your time, sir.
Thank you.
Thank you, Ms. Barrett.
Thank you, sir.
Up next, we have CCA, Mr. DeSalen. Is that right? No, that's not right. We have staff. I'm sorry, I was looking at the wrong line. Staff, is that right? Mr. Salen, you don't have any time with Mr. McKenzie. I just saw you pop up, I'm sorry. Since I mentioned you.
No, no, Mr. Hearing Examiner, I do not have any cross for Mr. McKenzie. Thank you.
Apologies, sir. Thank you. Okay, but
quite all right.
Mr. Foreman, you do. So is it 25 minutes?
Yeah, I do have 25 minutes reserved. Thinking it may not take quite so long, but
that's fine.
The questions are short. We'll see how long the answers are.
Yeah.
So, good morning, Mr. McKenzie.
Good morning, Mr. Borman.
Could you turn to your rebuttal testimony, page 27?
I'm there, sir.
Okay. And starting on line 5, you state there is no evidence that geography is linked in such a fundamental way to investors' evaluation of investment risk, or that regional boundaries should play any meaningful role in evaluating a fair ROE. Is that correct?
Yes.
Now, you discussed earlier a recent decision, I believe, in the Alaska Electric Light and Power Company case before the Regulation Commission of Alaska. Do you recall that?
Yes.
You were a witness in that case, were you not?
Yes, sir, I was.
And you filed testimony in that case in which you argued that Alaska Electric's geographic isolation was a relevant factor for consideration when characterizing operating risks that you suggested warranted an upward adjustment to your recommendation for Alaska Electric's ROE, did you not?
Yes, and I think there, again, the question is, how does that particular utility differ from the proxy group? I certainly didn't use geography as the basis on which to determine a proxy group.
Wait, but is it fair to say that geography of a utility would play some role in determining an appropriate return on equity for a regulated utility?
No, I don't think that's a fair statement as a generalization. I think in certain instances, such as in the case you just referred to in Alaska, where we have a single utility that's not interconnected with any others, and it's completely geographically isolated, that could be a factor. Mr. Dunn hasn't brought up any factors specific to New Mexico that would distinguish it from a utility in the western or central part of the states versus one in the eastern part.
Now, is it also true that in this Alaska Electric case, you stated that it is well established that smaller firms are more risky than larger firms?
Yes.
And further, all else being equal, it is well accepted that smaller firms are more risky than their larger counterparts. Is that correct?
Yes, that sounds correct.
And you supported a size adjustment to your CAPM analysis in this case, correct?
Yes, I did.
Okay. So then is it fair to say that the size of the utility is a relevant factor in considering when determining the appropriate return on equity for a regulated utility?
Okay, well, I guess the answer is you might be partly right. And here's where I need to just make a little bit of explanation. First, I want to distinguish between the size adjustment in the CAPM and the size premium that you referred to in Alaska. So the size adjustment in the CAPM is in response to financial research that shows that beta does not fully account for the risks that are associated with size. So the only instance in which I apply that size adjustment is with respect to the capital asset pricing model. Now, in the Alaska testimony, that was a much different scenario. There we had a utility which was, off the charts in terms of how small it was compared with the companies in the proxy group. So there, in an extreme situation like that, there was a basis to adjust the ROE upwards for size. In this case, I haven't seen any evidence that there is a direct relationship between the size of the publicly traded companies included in Value Line's electric utility groups and risk. So risk is the primary basis on which the proxy group should be established. I've looked at objective risk measures as the basis for doing that. And Mr. Dunn's suggestion that you can arbitrarily choose limits based on market cap, I don't think holds up to scrutiny because there isn't any relationship between those general size limitations he's put on the proxy group and risk.
Does that complete your answer?
Yes.
Okay. Could we turn to page 31 of your rebuttal?
Okay, I'm there.
Okay, and looks like lines 21 and 22 state that staff witness Dunn's failure to remove illogical growth measures undermines the reliability of his analysis and his biases, and biases his results downward. You see that?
Yes.
And a slightly earlier in that paragraph, you reference staff witness Dunn reports a projected EPS growth rate from Zacks of 1.70% for Northwestern Corp. Is that right?
For Northwestern.
Northwestern Corp.
Thank you.
Is that
Yes,
correct?
sir. Yes, sir, that's correct.
Okay, so, and it's that 1.7 percent for Northwestern Corp that is the illogical growth rate.
Well, the result of the combining that growth rate with his dividend yield produces what I would consider to be an illogical cost of equity estimate, yes.
Well, okay, and the growth rate, is it illogical because it is unusually low?
No, it's not illogical because it's unusually low. Again, it's the end result that matters. So we're looking at the results of the DCF model and trying to determine what makes sense and what doesn't, and what are we going to rely on and what are we going to question. And in my view, a cost of equity estimate that's basically equal to a BBB bond yield in today's market is not a logical estimate of the cost of equity. Investors require a higher return to bear higher risk. And if I'm an investor and I can go out and buy a bond that's going to yield 6%, there's no way I'm going to invest in a common stock for the same expected return. So on that basis, 6% doesn't tell us anything about what investors require.
Well, it seems like you're trying to back into the number here because you state, and this is your testimony. Staff witness Dunn reports a projected EPS growth rate from Zacks of 1.70 for Northwestern Corp. Later, you say his failure to remove illogical growth measures undermines the reliability of his analysis. That 1.70% from Zacks for Northwestern, that is the illogical growth measure. Is that correct?
Yes, that's the number I'm referring to.
Okay. But it's not the fact that it's 1.7. It could be, you're saying it doesn't even matter what that number is. Is that what you're telling me?
No, I'm not saying that. I mean, it does matter what that number is. But again, for the purposes of estimating the cost of equity, what we're really doing is looking at the output of the DCF, critically evaluating it and deciding, well, what are we going to rely on and what are we not? And Mr. Dunn,
you're backing into the number.
Well, you didn't let me finish my answer, but I'll disagree. I'm not backing into the number. What I am saying is that you should not include numbers in your analysis that don't make economic sense. So if a DCF analysis produces a result of 6%, but bond investors can earn that by buying a lower risk bond security, there's no way this 6% tells us anything about what common equity investors require. And on that basis, I don't think it should be included.
Okay. Do you have Mr. Dunn's testimony available?
Yes.
And I'll refer you to his exhibit CED2.
That's CED2?
Correct.
Yes, I'm there.
Okay, and we see this table on the top of CED2. Is that, you find it?
Yes, page 1
Okay.
of 1. Yes.
And towards the right, there's a column that says earnings growth and estimates. Do you see that?
Yes.
And within that, there's a column for average growth. And then there's Y Finance, which I believe is Yahoo Finance. and Value Line and Zacks. You see that?
Yes,
Okay. And then about halfway down the column, we have Northwestern Corporation. And if we go across this line of Northwestern Corporation, we get to average growth 3.23, Yahoo Finance 4.50, Value Line 3.50, and Zacks 1.70. You see that?
yes,
And it's that Zacks 1.70 that you object to. Is that correct?
yes.
Okay. Now let's go up a couple of lines, 3 lines to where I think it's pronounced Elite, ALLETE. You see that?
Yes,
What is the Zacks number there?
9.6.
Did you object to the inclusion of the 9.60 in Mr. Dunn's analysis?
No,
So Mr. Dunn's analysis shows and the sum, the average of the average growth column is 5.49. Is that correct?
yes.
Okay. What's the difference between 1.7 and 5.49?
Well, I don't have a calculator. If you've worked it out, you can tell me.
Okay. Well, let me ask you this. Is the difference between 1.7 and 5.49 greater or less than the difference between 9.60 and 5.49?
It's less.
You're saying the difference between, and you've done that math? If you've done that math, why don't you share it with us?
The difference between 549 and 170 is less than the difference between 960 and 170.
Okay. Okay.
Yeah.
Understood. Now, can we refer to Mr. Dunn's exhibit CED3?
Okay, I'm there.
Does this exhibit show that Mr. Dunn analyzed an alternative peer group consisting of 20 utilities in addition to his preferred peer group?
Yes, it does.
Okay. And is it true that staff's recommendation of 9.45% for an ROE falls within the range established by both staff's recommended proxy group and the alternative peer group that we're looking at?
Yes, it does fall within the range.
Okay, thank you. I have no further questions. Thank you very much. I think we're probably getting close to lunchtime, so I hope we all have a good lunch.
Thank you, Mr. Borman. Mr. Alvidrez, let's see. Actually, before I ask you whether you have any redirect, hearing examiner Ryan.
Yeah, let's just have a few questions. Mr. McKenzie, how are you, sir?
I'm well, sir.
The commission has, in previous cases, spoken about its preference for the DCF model in terms of setting the return on equity. Are you aware of that fact?
Yes,
And I believe you quote Dr. Morin and New Regulatory Finance as an authority to say that over-reliance on a particular method is error. Is that correct?
yes, I don't think it's appropriate to rely on any single method.
And so I had Dr. Morin in the last gas company rate case that I was involved in, and we had rather robust exchange about that very subject. So can you say for this record, why is it that, and I understand it's in your testimony, but I'll just give you an opportunity if there's anything you wish to add to the subject, reliance on the DCF model as a sort of principal method would be problematic.
Yeah, and let me make clear that I'm not taking issue with the DCF method. Obviously, I employ that in my testimony, and I think it's a widely accepted approach, and the commission should continue to rely on the results of the DCF method. So I don't think there is anything fundamentally wrong with the DCF approach. What I do think is that all of the methods that we can look at to estimate the cost of equity are just that. They're tools, they're estimates, they're based on a variety of very complex and restrictive assumptions. None of these assumptions are met in practice. So there is always the potential for any single method to produce a result which is not indicative of the cost of equity. And I think it's widely accepted within the financial community, whether it's in the investment community or in the realm of ROE determinations, that it is preferable to look at alternative approaches because we're getting more information. And given the fact that we can't directly observe the cost of equity, it's important to consider alternative methods as a way to get our hands around this. I mean, I was interested to see, NARUC recently published a guidebook for developing economies. Obviously, countries that are wanting to either institute or improve their regulatory systems. And that guidebook specifically talked about cost of capital and the importance of acknowledging the results of more than one approach. So, this is not any kind of departure, I don't think, from standard practice throughout this industry. I think regulators across the country have acknowledged the importance of looking at alternative methods, and I think this commission should do the same.
When your response there, when you're talking about the necessity to have multiple models to project the cost of equity, is the basic thought underlying all of that? I'm posing this as a legitimate question. I'm not trying to make an assertion in the form of a question. Is it necessary to have multiple models because assigning an appropriate return on equity is inherently subjective?
Well, I think at the end of the day, certainly informed judgment plays a role. I don't know about subjectivity, but certainly informed judgment has to play a role because, again, there is no perfect tool. Unlike a bond, we can't just go out in the market and look as to what investors require on a common stock. We have to infer it. And there's been various approaches developed to aid in that exercise. But ultimately, the commission is tasked with the responsibility to weigh the evidence that's presented in each case and make that determination. What I think the commission should do is consider all of the evidence. There isn't a reason to be afraid of more information. And I think CAPM, ECAPM, risk premium models, and earned returns on book value are all benchmarks that the commission can use in its evaluation of the evidence.
And Mr. McKenzie, did you look at some of the analyses that have been done of the rate of return by these hearing examiners, or this one in particular, me?
No, I'm not familiar with your
So
honor.
Okay. So if I have looked at those different models, then that would be consistent with what you're recommending, correct?
Yes, sir, it would be.
Okay, thank you. I'll let the parties do some digging on that, but we're aware, sir, of your recommendation. We've heard it before from other experts of your caliber. Thank you, sir.
Well, and it's not just me. All the other.
No, it's Mr. Heather. It's Mr. Gorman. It's lots of folks. Go ahead.
would you also say that, in fact, the interveners analyses are themselves useful for determining the question in this case? As a matter of fact, would you say that they are essential?
Well, it's all part of the process, Your Honor. I mean, I think, again, coming back to some of the arguments that have been made in this case about whether allowed ROEs are inherently overstating the cost of equity. I mean, everybody gets a shot at a bite at the apple here. Everybody gets to put on their case, to present evidence. And obviously the other witnesses have done an in-depth study of the ROE, just as I have. That's part of the process. The commission's job is to weigh the evidence. Do I think that the other recommendations are credible? No, I don't. And I've addressed that in my rebuttal testimony. And I've explained the reasons why I think they all fall short of what the cost of equity is. But I think, again, coming back to the essential nature of this process, it's one in which everybody gets to present information that the commission can consider and do its best job at deciding what is the cost of equity. So, and I don't see any basis upon which to say that this process is somehow corrupted or thwarted or otherwise skewed towards higher ROEs than lower.
Or lower than higher.
Or lower than higher.
Yeah, that's the sort of next step in that thought, I suppose, which is, I mean, I don't hear you to be saying, and you can correct me if I'm wrong. I mean, I read your, and I'll just preface this by saying this. I mean, I read your testimony and I've read your response to Mr. Garrett, and you clearly disagree with him, and that disagreement is quite strong. But I don't understand you to be saying Mr. Garrett is empirically or foundationally wrong, because no one can, as you have just said to us, in some depth, attest to hold an empirical truth to the question, an answer, that is.
Well, here's the rub. I mean, there's certain relationships in finance that are self-evident. And one of those is that the cost of equity is an opportunity cost, and it's contingent upon what investors could do with their money absent the opportunity to invest in PNM or any one of the other utilities in the proxy group. When bond yields go up, okay, and bonds are less risky than common stocks, that suggests, that doesn't suggest, that demonstrates that the cost of capital has moved higher. Every one of the witnesses in this case are suggesting that PNM's ROE should be lowered from its present level, even though interest rates have moved substantially in the other direction. That's an empirical demonstration of an illogical outcome, in my view. I don't think you can.
But there's a lot in your postulation, right? Because the companies that you put in that proxy group and the values that you assign colors the result that you receive, right?
But I'm saying let's forget about proxy groups. Let's forget about.
No, you said proxy group though. I heard proxy group in that. Do you want me to go back to real time like we did with Mr. Graves yesterday?
We could.
No. Okay, you could. You said. Go ahead.
No,
go ahead and I'll remember proxy groups. You go ahead and forget them for now. Go ahead.
Okay. Well, all I want to say is that, we've got a lot of testimony in here on the minutia of how to apply various financial models, and all the witnesses are disagreeing about size adjustments, growth rates, and everything else. What I'm saying is the last time interest rates were as high as they are now, the average allowed ROE in this country was 10.5%. If you go back to 2005 to 2011, when interest rates on average over those years were comparable to what we're seeing in the market now, if not a little bit lower, ROEs were right around where the company is requesting. You can't get from 9.5 down based on changes in interest rates, and interest rates are a fundamental driver of opportunity.
I understand, but now but you can't take that period back then and say it's the same period now. There are a lot of other dynamics going on in the economy, aren't there? You're just that was a very simplistic approach that you're criticizing other folks of being simplistic about. But that is in and of itself was simplistic comparison of economic conditions in an earlier period to what they are now and the complexities involved in the very, very many moving parts of the economy right now. Isn't that a fact?
I disagree and I don't disagree. I agree with you that there's a lot of complexities that are driving underlying economic situations and what drives interest rates, for example.
Right.
Conditions that are driving interest rates right now are not the same as those that prevailed back in 2005. I'm not disputing that. But what I am suggesting is that this opportunity cost principle and the link between debt costs and the cost of equity is still here. It hasn't changed.
And I guess just to clarify one thing I'd ask, and I believe Mr. Medeiros is sort of pointing towards this. I mean, we are sort of and I'm not trying to interject matters not in testimony. So if you want to correct me if I'm wrong, I'm not an economist, but I do read newspapers, and I do believe it's the case that historically we're in a very strange moment with interest rates, right? Like this is unprecedented for the time that I've been alive.
I don't agree with you. I mean, I think we were in an unprecedented environment a couple of years ago when the Federal Reserve basically drove long-term treasury yields down to historically low levels. I think what we're seeing now is more of a return to normal, and it's been a very swift return. Obviously, we're dealing with an inflation rate at least over the last year and a half, which has been quote unquote unprecedented in recent history, but is not unlike conditions in the past.
No, it's not like conditions in the past because of the continued job growth, economic output, job growth, all of these different factors. It's different in this current period than it was before.
Right. And I think, again, coming back to your Honor's point, there's any number of specific conditions within the economy or the financial markets that are different from any other previous time. And yes, and the other thing is that boils down into an observable benchmark in the capital market, which is an interest rate that we can look at. We don't have to estimate it. And there's, again, that same link between bond yields and the cost of equity.
Just two questions about sort of what are other fundamental. If I understand correctly, Mr. Borman brought this up, or it wasn't Mr. Borman, it was someone else, one of the other interveners. PNM has over-earned and was then obligated to return money to ratepayers. That's correct, right?
Yes.
How is that not a sort of empirical or fundamental demonstration that the cost of equity is correct, if not too high?
Well, the earned return and the cost of equity are two different concepts. I mean, there is kind of a relationship, I guess. I mean, I talk about that within the context of the expected earnings approach, but the cost of equity is determined by investors. The authorized return is determined by the utility, and then depending on circumstances that the company faces, it will either over or under return. It may even exactly earn that return, but we don't know. That's the risk. And so
isn't the authorized return authorized by the commission?
Exactly.
You said the utility.
Sorry, the commission. Thanks for correcting me. Yeah. Yeah, so again, the fact that the company over earns in one year and under earns in others is not to be unexpected. That happens.
It underscores that this is an inexact science.
Well, and it underscores the fact that a rate case is a snapshot in time, and what
Yes.
happens after
Yes.
the rate case is done, it's going to
Yeah.
be different.
Yes.
One of the other foundational principles that there seem to be disagreement about between yourself and then the interveners has to do with, and I forget where exactly this plugs into the analysis, so perhaps you can remind me. There was the assertion that utility earnings cannot exceed GDP or the growth. Did that ring a bell?
Sure does.
Could you just refresh my memory on that subject? And then the question I'd like to ask is, to me, that sounds like a very intuitive principle. And you know, I've read your testimony. It's a lot, right? You know, there's a lot of information in all this, but why is that not just foundationally and fundamentally correct in the same way that you point out that, you know, bond levels necessarily tell us something about what the ROE should be? Well, shouldn't the national economy tell us something about what return on equity for utilities should be, because they're sort of connected at the hip, if you will?
Well, certainly the state of the national economy underlies growth expectations for utilities. There's no question about it. But what I'm saying is that the degree to which economic growth in the foreseeable future is going to influence the earnings growth of the utility sector is considered by analysts. Now, Mr. Garrett takes the position that actually the only thing that matters is long-term GDP growth. So one of his DCF analysis ignores company-specific data completely and just plugs in the GDP number for every company. So
Does it also ignore, and you may agree with this, the impact of the Inflation Reduction Act?
Sure. And the entire, I mean, the other problem is that.
And why would it be about the Inflation Reduction Act? Can you amplify on that?
Because there's widespread expectations for capital additions. Obviously, PNM is in the midst of a significant capital improvement program. Those capital additions drive growth for a utility because clearly they will be added to rate base.
And
so we're not.
And the Inflation Reduction Act facilitates.
Yes,
doesn't it?
Yes,
right.
It does. Right. So this GDP thing, it's a very theoretical argument that basically says, you know, everybody knows that in the long term, when we're all gone, there's no way any single firm can grow faster than GDP because eventually it'll overtake GDP. Well, let me tell you, I mean, if you took one of these utilities, we'd probably be looking at 500 to 1,000 years before any one of these firms overtook the $20 trillion of US GDP. It's an entirely theoretical argument, which has nothing to do with what investors expect, with what investors look to when they decide to buy a share of common stock in the market. None of these witnesses have presented any evidence from investment publications that say, you know, here's our expectations for Exelon for the next 5 years. But by the way, be mindful of the fact that their growth is constrained by GDP, and we should be, you know, we should consider that when we're evaluating these shares. But investors don't have 100-year horizon when they look at projections.
Are you an expert on investor behavior, though? Do you know who the rational investor is and why they're investing?
Or whether there is a rational investor? Yes. I mean, I'm not an.
Well, they might be looking for. Go ahead. No, go ahead.
No, I mean, what we're looking out at is the types of information that investors consider. we can't get in the mind
Right,
of the
right.
investor, but we're looking at what are they looking at? We're also looking at how others apply these models. We're looking at financial research that
Yes.
talks about the applicability of growth rates and the horizon of investors. And there's nothing to suggest that investors are looking at GDP growth if they apply a DCF model to estimate a hurdle rate for electric utilities.
And isn't this why long ago the Supreme Court and it supplied us a cheat code? You know what that cheat code is?
No, I'm not sure.
The zone of reasonableness.
Ah, okay.
Go ahead, Hearing Examiner Ryan.
I want to just discuss quickly when I read the testimony, and I think Ms. Crane is the first, I mean, she's not the only one who references it, but I believe when I was reading the testimony, I read hers early enough that that was the first time I read it. It's like 30%, it's a full third, I forget the exact number, of PNM's revenues are all collected through automatic adjustment mechanisms and riders. Do you remember that portion of her testimony or any other interveners' testimonies?
I remember reading that something similar in Mr. Sandberg's testimony. I don't believe I read Ms. Crane's testimony.
And maybe I'm mistaken in Ms. Crane, but in any case, you don't dispute today that that's what they're offering as a fact.
I'm not disputing the fact, but again, as we discussed earlier today, if these mechanisms are so great, why is PNM falling short of earning its allowed ROE in 3 of the past 5 years? It's not a risk elimination program. And the other factor is, let's take fuel costs. I mean, which is rolled into this. PNM is a price taker. It doesn't affect energy costs in the market. So if you want to take away the fuel adjustment clause and go back 50 years in time to when utilities were exposed to those kind of risks, we would be having another conversation about what the ROE would be. And it's not going to be 10.25. It's going to be something much higher because look at volatility in energy costs. This is not a profit center for PNM, and I don't agree. I mean, I'm not an expert in fuel costs, but certainly my experience suggests that the fuel procurement activities of utilities are inspected by regulators, and if they have a problem with them, the utility is sure to hear about it. So it's not like there's no incentive for the utility to do a good job of acquiring fuel at lowest cost, but it can affect market prices.
So I guess what I would ask, this comes up, that's a portion of the discussion, and then, these adjustment mechanisms, and to what extent does the utility have sort of locked in revenue that will adjust automatically? That's just one part of it. And then we throw in decoupling. And I think the more broad point about all this, and the reason why the questions come out, is it seems the fundamental proposition would be something like, to the extent to which the utility can organize itself as a business to reduce risk, that should be reflected in whatever the allowed return is. Do you agree with that basic proposition?
Yeah, that's a very basic proposition, and I would agree. If risk goes down, then the ROE should go down. But again, within the context of examining this, we are looking out into the market at a proxy group. So if the company's risks were lower than those reflected in the proxy group due to some consideration, and regulatory mechanisms maybe could be one, then there could be some basis to distinguish. But because these mechanisms are so ubiquitous throughout the industry, we've already captured the impact of that when we apply the models to those companies in the group.
Do you know off the top of your head, PG&E's, the electric subsidiary, its current allowed authorized return on equity?
Pacific Gas and Electric Company?
Yes.
No, I know it's above 10%, but I'm not sure what the exact figure is.
But PG&E has full revenue decoupling, doesn't it? For all
Yes,
rate classes?
they have what they call balancing accounts in California, but it's a similar process.
I thought in your testimony, and I this is more a discussion than it is. I'm trying to remember what the status of PNM's decoupling appeal is. Is that still pending, Mr. Medeiros?
I'm sorry?
I'm just trying to recall.
Oh, no, I do.
Is that decoupling decision still pending an appeal?
It has not, and correct me if I'm wrong, but I believe it has not been argued yet. Briefs may have been submitted, but it's still pending, yes.
So the only thing I would say there, and if Mr. McKenzie, you can correct me if I'm wrong about this, it's my understanding that PNM does believe it has a decoupling mechanism.
Well, I don't know what PNM believes, but I don't think until it's approved, investors believe it. So they're going to want the writing on the wall before they adopt. But again, even if that's approved, as I point out in my testimony, that's not inconsistent with the other companies in the proxy group.
Well, that's why, and I'll assure you, Mr. McKenzie, and I'll assure the company that that's not going to be weighing into our assessment, because we understand precisely that the Supreme Court has not acted on that disputed, that contested issue on appeal of the decoupling mechanism.
No, I'm mentioning only from the perspective of, at the broader level, if you do operate in an environment where there is risk removal, then that somehow should be, reflected in the return on equity. I mean, that seems, and then, Mr. McKenzie didn't disagree with that. He just qualified to say,
no,
that's a complicated point, but, all right. A couple just final questions.
No, I just wanted to point out that it's something important to consider going forward in the next rate filing, depending on what happens with that decoupling proposal that is on appeal. It may be salient in the next case.
And I'm not, I'm asking this as a legitimate question. When you read the testimony in this case, and you learn that 41% of PNM's customers exist within 200% of the federal poverty line. Does that matter for purposes of the return on equity discussion?
Well, the honest answer is no. And the reason is, again, like the cost of natural gas or the cost of copper wire or the cost of labor, capital is provided by investors in a market, and a market sets a price. And PNM is a price taker, and investors are not influenced by the number of customers that are facing economic hardship in terms of deciding what is the cost that they require to either lend money in the form of debt or purchase a common stock. That's just kind of the hard fact of a competitive capital market. There's any number of ways that income disparities might be addressed, but they are not considered by investors when they decide what return they require, either for debt capital or equity capital. The only other consideration is that sometimes if the utility is operating in an economically depressed service territory, it actually could imply higher risk, because then you get into a situation, and we've seen this more recently in some of the credit rating agency reports, where they're outlining, and this was back earlier in the year when gas prices were spiking, and last year, the affordability crunch, where investors are worried that regulators are not going to allow ROEs that reflect the cost of capital because of affordability concerns. And the ROE is not a fudge factor. It's a cost that's determined in the market.
And I guess I'm asking in part because, we have Walmart in this case, and they've chimed in their testimony on the subject of the requested return on equity is interesting because whether I'm reading between the lines here or not, I don't think I am. And if, they have to pass along costs of energy to customers, and, the customer doesn't have infinite money.
Right, and clearly they have a legitimate interest in their own competitive position. So I'm not disputing that.
Yeah, as a publicly traded company, they have to exist within a milieu that has limitations, as I presume PNM does as well.
And their duty is to their shareholders, and clearly higher profits are beneficial to them.
Okay, thank you. Mr. McKenzie, that's all my questions.
Thank you, Your Honor.
Mr. Alvidrez, redirect?
Yes, a few questions, if I might.
Sure, of course.
Mr. McKenzie, you were asked some questions about ROE and whether ROE should take into account the relative wealth, I guess, of a utilities customer. I think you explained why you think that is not a factor to consider in determining the ROE. Are you aware of other methods, other mechanism, I should say, to address concerns such as those raised by hearing examiner Ryan with respect to other aspects of utility rate making and rate design and that sort of thing?
Well, I'm not an expert in that area. I would point out, though, that the company already has taken one step to at least partially address this issue, in my view, because they're requesting an ROE that falls below the middle of my range. So they have made a downward adjustment to their ROE request, which I think was specifically designed to reflect concern over customer affordability. In terms of other ways to address the issue, certainly rate design can play a part. Customer allocation between customer classes is another one that frequently is used as a way to mitigate the impact on residential consumers.
And there's been a discussion about geography and the role it should or perhaps should not play with respect to establishing an ROE. Does geography play a role with respect to risk? Or can it?
Well, it can. I don't dispute that. I don't believe that as a general principle, geography provides a sound basis to establish a proxy group, because PNM competes for capital in a broad national capital market. But certainly there can be situations where geography can imply risks that aren't faced in other jurisdictions. So, for example, Entergy Louisiana and Florida Power and Light face extreme storm risk of hurricanes. So that certainly has implications. Other utilities that maybe rely primarily on hydro could face drought risk if water supply dries up and they have to go out on wholesale markets to buy power. That can be a risk consideration that might come into play. But as a broad general principle, I don't think that simply saying that, well, we're more in the West than we are in the East justifies excluding companies that are in the eastern part of the US from a proxy group.
Well, that was going to be my follow-up question, is whether geography should play a role in the capital market.
Well, I think, again, to the extent that geography influences risk in a meaningful fashion, capital markets would consider it.
And you've talked about benchmarks in a number of contexts, and you've referred to looking at other awarded ROEs and said they can serve as a benchmark. Can you elaborate on that? What value is that data in determining an ROE?
Well, I talk about this in the context of my risk premium approach, for example, because it's based on allowed ROEs back to 1974. The presumption is that just like this commission, other commissions in the process of setting ROEs, or in the case of settlements, informed parties present evidence. They have an idea of what models are producing what results. And there is a determination based on this evidence as to what the cost of equity is, either within a litigated case or in terms of a settlement. It's the parties negotiating across the table and they're informed. So that becomes, number one, it becomes an observation point, a benchmark for the cost of equity. It's also something that's referenced by investors. So the reason that S&P Market Intelligence puts out a quarterly publication that presents average allowed ROEs is because investors want to know. They consider that in their overall assessment of that opportunity cost principle we talked about earlier. So they are a benchmark. And they're frequently cited. But as my testimony makes clear, the important part that I don't think any of the other witnesses really examined is you can't take a number under one set of capital market conditions and then apply it to today when those conditions are different. So I think that's the important driver, is that we have to control for the change in interest rates. And there has been a very significant upward move in interest rates in a relatively short time period, so that allowed ROEs over the last several years are not a direct benchmark for today.
Have you seen any evidence or data indicating that the Inflation Reduction Act is driving inflation down?
Well, I mean, I've certainly seen evidence that inflation rates are falling, and I think the Federal Reserve's policies have obviously proven to be effective. And if you look at headline inflation numbers like the CPI, it's fallen significantly. I think the other point to take away with is,
core inflation remains high, though, right?
Well, it's lower than it was. I mean, the core.
Yes, it is lower than it was.
Core PCE peaked at 5.4%, and it's now around 4.2, which is still double what the Fed's target of 2% is. So I don't think the Federal Reserve is going to reverse course and start to lower rates anytime soon.
Has the Federal Reserve said anything about the 2% rate of inflation in terms of a target?
It has steadfastly maintained that target, and Chair Powell made it very clear in his speech at Jackson Hole and in previous speeches that they are determined to reach that, and they will not alter policy until they've gotten there.
And my final question is, are there consequences for setting an ROE that is below market?
Yes, there certainly are. I mean, I gave an example in my rebuttal testimony. Mr. Sandberg points to a decision in Arizona authorizing originally an 8.7% ROE for that company, and he suggests that should be a touchstone for this commission. And as I point out, investors reacted very negatively to that decision. the company's bond ratings fell and the stock price plunged. And that's just the opposite of the Hope and Bluefield standards. That is not maintaining the utility's financial integrity and ability to attract capital. It's undermining it. So to the extent that an inadequate ROE is allowed, that leads to poor financial metrics in terms of cash flow. Ultimately, depending on the severity of it, it can undermine the company's credit ratings. That leads to higher borrowing costs, which is passed on to consumers. And, obviously, this utility, I'm sure, will make the investments that are necessary to guarantee service reliability, but it does undercut the incentive to do more than that, to the extent that there are additional improvements that could benefit customers, perhaps through reliability or access to lower cost power. Those may not happen.
Thank you, Mr. Hearing Examiner. Those are my questions.
All right. Thank you, Mr. Alvidrez. Let's see, Mr. McKenzie, I want to thank you very much for your testimony.
Mr. Medeiros, real
your-
quickly, Commissioner Ellison joined us just a moment ago. And I don't know if he's here to ask Mr. McKenzie questions or not.
Well, if he is, he is more than welcome to ask Mr. McKenzie questions. Yes.
Thank you. I don't want it to greatly interrupt the schedule. I'm guessing it's time for lunch break now.
If you'd like to come after lunch, we could do it then.
What time will you come back?
1:30.
I see.
If you prefer go now, that's fine.
That's fine too. It is.
Maybe just a few minutes, because unfortunately I've got a scheduled meeting at 1:30. I would like to ask just a few questions. So,
Mr.
This
Lee,
is
is that okay with you real quickly?
Yes,
You're all right with
sir.
that? Thank you, Mr. Lee.
great. Thank you. Hi, Mr. McKenzie. Good afternoon.
How do you do?
Good, thank you. I wanted to ask you a few questions with the CAPM model. It wasn't immediately clear to me what beta you used for that.
I sourced my beta values from Value Line.
Okay, but what were they?
Those are listed on Schedule AMM-7 to my direct testimony. So those beta values, I guess, they range from, looks like a low of 0.8 to a high of 1.15.
I see, and these companies are all holding companies, correct?
Yes. Well, they're not all holding companies. They're all publicly traded. For example, Avista is not a holding company.
Is it an operating company?
No, I mean, there is within Avista Corp, there's a utility group, but it isn't a holding company. But
I see. The distinction I'm making here is that we're focusing on PNM, which is an operating company, and these all appear to be at a higher corporate level, correct?
Yes, I mean, many of these companies would have underneath that corporate umbrella, they may own one or more operating companies like Public Service of New Mexico.
And so you've got the potential, or really the likelihood, that at the holding company level, there's going to be debt as well. So the holding company will have debt an equity of the operating company, correct?
Yes, in many cases, these corporate entities may issue their own bonds, as well as there may be bonds issued at the operating company level. Yes.
And so when you think about the beta for these holding companies, which have more debt than the operating companies do, I guess first of all, the beta in this table, have these numbers been adjusted for the various levels of debt in these holding companies?
I'm not sure what you're referring to. I mean, these beta values are just purely based on a regression of the stock price variation for each firm versus the market as a whole. So there's no and that they are adjusted for a movement towards one, but there hasn't been any other adjustment to those beta numbers.
Wouldn't you agree that, the more debt a company has, the less its stock is gonna be moving with the market?
No, I don't think I'd agree with that. I mean, I think debt ratio, financial leverage is certainly one part of the puzzle in terms of evaluating overall risk, but you're kind of presuming a direct relationship between the debt ratio and the volatility of the stock price. And I don't necessarily believe that's true. I mean, I think I point out in response to Mr. Garrett, there's no empirical relationship between, for example, his betas and the capital structures of those firms.
Okay, it would just stand to reason that, if a company has more fixed debt, I mean, they issue bonds at a fixed rate and they've sold those bonds, that they're going to be less exposed to stock price movements. Would you not agree to that?
Well, I mean, the company is not exposed to stock price movements. I mean, it's the common equity investor that faces
Sure.
volatility. But again, I don't dispute the idea that debt leverage is one risk factor, but it's only one. So companies might use different amounts of equity or debt depending on the particular operating circumstances that they face. So I don't think you can just look at the debt ratio and say, and posit this relationship between beta.
And so what was the average beta you used? I see this list of betas in the table, but I don't see an average.
The average is presented in my direct testimony on page 10, and it's 0.9.
I mean, on the face of it, doesn't that strike you as strange that a utility stock where you've got, a regulated company with no competition has a beta of 0.9?
No, it doesn't. I mean, 0.9 is less than the market, which is what you would expect. Utility betas have fluctuated, certainly over time. Sometimes they're higher, sometimes they're lower. But I think it's an accurate reflection of how those prices have moved. And within the context of the capital asset pricing model, that's all that matters is how do stock prices move relative to the market? And that's what beta measures. So I don't have any reason to question that.
Well, certainly you'd expect the risk of bankruptcy to be a lot less in in a regulated monopoly than you would in a just a regular firm that faces market forces, wouldn't you?
Yeah, I guess in a general sense, I could agree with that. But when we're talking about the capital asset pricing model, all of those risks, whether it's exposure to bankruptcy or ability to alter prices or potential competition, it all boils down to beta.
What risk-free rate did you use?
And again, that's on Exhibit 7. And I based my risk-free rate on a 6-month, on an average yield, an average yield for a 30-year treasury bonds. I performed 2 analyses, one with, on page 1 of Exhibit 7, you can see I used a risk-free rate of 3.6%, and that was based on September 2022 averages. And I also developed a CAPM using a projected bond yield of 3.8%.
Okay, and the risk premium, is it this 8.6% that's on the table?
Yes.
And how did you find that?
Well, that's the difference between the risk-free rate and the 12.2% implied market return that I developed based on the S&P 500 companies.
That's quite an incredible number as an investor. I would love to have a 12.2% return going forward on my market portfolio. How does that compare with what some others in the field, like Professor Damodaran, have come up with?
Yeah, I'm not sure offhand what Professor Damodaran's current version of the market return is. It's probably, I think it's in Mr. Garrett's testimony and Dr. Woolridge's testimony somewhere. If you want me to find it, I can look through.
No, that's okay. Yeah, I think it's going to be somewhere in the 5% range is what Professor Damodaran. I'd have to look at today's or the most recent figures, but it's going to be around 3 percentage points lower than your estimate of the risk premium.
It may well be, but again, going back to some of the discussion we had earlier about opportunity costs, if I can invest in a utility bond today and get 6% on my money, I don't see why I would take on the extra risk of investing in the stock market as a whole for an extra 1%. That doesn't make any sense.
Well, I mean, the risk, we're looking at what is the projected growth minus the risk-free rate. So I'm not sure where I see the utility bond yields come into play in that calculation.
They don't come into play in this calculation, but they certainly come into play when investors look out at opportunities. Where can I put my money? Do I buy this bond and I know if I hold it to maturity, I'm going to get my money back? Presumably, there's some risk, but it's manageable, and I'm going to earn a return of 6%. If I go out and buy a BBB utility bond in the market today, I'm going to get 6%. And I think you suggested that Damodaran's saying that you can buy the S&P 500 for an expected return of 7%. And I'm saying I wouldn't make that bet. It doesn't make sense to me. I mean, the 12.2%.
No, I didn't say 7%. I mean, if we even take 5% and add it to the 3.6, it would be, 8.6.
Okay. Well, in my view, that's still far short of the required return on the market as a whole. The problem with a number like that is basically none of the witnesses in this case are recommending return below 8.6 for Public Service New Mexico. And I think we can all agree that Public Service New Mexico is less risky than the market as a whole. So it kind of tells you how much weight to place on that data. I mean, if these witnesses really thought the market was yielding, that investors believed an 8.6 return was fine on the market, they'd be recommending a return for P&M of 7.2 or something in that nature. Nobody's doing that.
Okay. I guess that's all the questions I'm gonna have. I'm gonna have right now.
Thank you, Commissioner Ellison.
Thank you.
Thank you.
Mr. Alvidrez, any follow-up?
No, Mr. Hearing Examiner, no redirect.
Okay. All right, Mr. McKenzie, thank you very much for your testimony. And thank you very much for playing along so professionally and well. We appreciate it.
It was a pleasure.
Good stuff. Thank you, sir. You are excused. And Mr. Ryan? Okay. So with that, I have folks popping up. I'm going to excuse the rest of you for lunch for an hour. So we'll be back at 1:45, and I promise that when we come back, we will close the hearing by 5 p.m. today. But we will take a break, maybe a 10-minute break later on the day. But let's recess now for lunch until 1:45 p.m. Have a good lunch, all. Thank you.
Mr. Ryan, do we know who the next witness is?
Don't recall. I had to look up that sheet again.
I don't recall either.
This is Rick Alvidrez. PNM's next witness is Sabrina Greinel.
Okay, we're back to the order on the chart, the larger chart.
Yes.
Yeah. Okay. Thank you.
Rick, I have a question to ask you. Would you oppose bringing Sanders back for limited cross-examination on PNM's bench request number 3?
We don't. He can't go today, but next week would work. We can talk to the hearing examiners about their pleasure if they're interested in bringing him back.
Okay, thank you.
Just waiting on Mr. Medeiros. Sorry, Mr. Herman, go ahead. We're not on the record yet, Mr. Lee.
No, Rick, I was just going to ask you, I don't have much cross-examination for Ms. Grunell. Ms. Grunell, good to see you again, but most of my cross is going to be admitting ABCWA exhibits 4A and B and 5A through D. And if you'd be open to stipulating their admission, we might be able to save some time.
Which 4A and B, is that all? Or 4A and which
4A
ones?
and B and 5A through D. I'm not going to have any cross on them. I was just going to get them admitted, and hopefully it's all moved with the settlement being approved.
I'll stipulate, Mr. Herman.
Thank you, Mr. Lee. I appreciate it.
I'm a nice guy that way.
Well, can we maybe take care of that a little bit later or come back to that?
I just asked Mr. Examiner because I have a appointment at 2:30, so I was hoping we could get going. I don't see Jeff here, so I think I'll be up first for Ms. Cornell.
Right, but we had the exhibit issue first. And I'm not sure PNM's prepared to provide you the answer yet.
I have had a chance to look at Exhibit 4A and 4B, and I have no objection to either of those. And I'm sorry, Keith, exhibits.
We'll take care of it on the record.
Okay. Great idea. Let's do that.
Okay. But we could do that on the record, but are they in the Dropbox folder?
Yes, they've been in the Dropbox since last Friday.
All right, well, we have different folders for different folks. Yours is in the main exhibit. Yours being the water authorities is in the main, what do we call it? The exhibit exchange folder, correct?
Yes.
And it's 4A and 4B there, correct?
Yes.
Okay, all right, let's go on the record then. Mr. Lee? Thank you. I hope everybody had a good lunch. Shocked how fast these breaks go. So we're about to start the next examination of PNM witnesses, and I'll ask Mr. Alvidrez to introduce your next witness, please.
Yes, Mr. Hearing Examiner, we call Sabrina Greinel as our next witness.
Ms. Grinnell, will you please raise your right hand? Do you solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Ms. Greinel, can you please state your name, employer, and position for the record?
Yes, my name is Sabrina Greinel, Greinel, and I serve as Executive Director of Treasury for PNM Resources.
And Ms. Greinel, did you prepare direct testimony in this case that was filed on December 5, 2022?
Yes, I did.
And do you have any corrections to make to that testimony?
Yes, I have one correction.
Okay, could you tell us page and line number?
On page 20, line 14, the word shareholders should be replaced with the word ratepayers.
Okay. And do you recognize PNM Exhibit 13 as your direct testimony that we've just described, including the corrections you just read into the record?
Yes.
And is your testimony as corrected, true and correct to the best of your knowledge and belief?
Yes, it is.
We move the admission of PNM Exhibit 13.
Any objection? PNM Exhibit 13 as corrected is admitted.
Okay. And moving on, Ms. Greinel, did you prepare a rebuttal testimony that was filed in this case on July 28, 2023?
Yes, I did.
And can you confirm that PNM Exhibit 14 is a true and correct copy of that testimony?
Yes.
And is your testimony as set forth in PNM Exhibit 14 true and correct to the best of your knowledge and belief?
Yes, it is.
Mr. Hearing Examiner, we move admission of PNM Exhibit 14.
Is there any objection? PNM Exhibit 14 is admitted.
And with that, Ms. Greinel will stand for examination.
Thank you, Mr. Alvidrez. Looks like Mr. Albright is not present, so we'll move to the next cross-examiner, and that's the Water Authority, Mr. Herman.
Mr. Examiner. Good afternoon, Ms. Cornell.
Good afternoon.
And you have, I'm sorry, Ms. Greinel. You have 40 minutes, correct?
Yes, as I was stating off the record, I won't be using that. I have a commitment at 2:30, and once I conclude my cross-examination, Mr. Harris will be taking over for the Water Authority for the remainder of the day.
Okay.
Ms. Granell, do you have access to the exhibits that were uploaded by the Water Authority prior to hearing?
Yes, I do.
Could you please identify exhibit 4A, ABCWA exhibit 4A and 4B?
I see them, yes.
And those are your responses to ABCWA interrogatories 7-31 and 7-32, correct?
That's correct.
And if I asked you those questions again today, would your answers remain the same?
Yes, they would.
Thank you. With that, I will move to admit ABCWA exhibits 4A and 4B.
And no objection from P&M.
ABCWA exhibits 4A and 4B are admitted.
Thank you. That is a mouthful of letters and numbers to say. Ms. Grinnell, I'm going to do the same process, except this time for ABCWA exhibits 5A through 5D.
Here, let me just open those.
Sure.
Okay, I have them open.
And those are your responses to ABCWA interrogatories 8, 12, 13, 14, and 25, correct?
That's correct.
And if I asked you those questions again today, would your answers remain the same?
Yes, they would.
With that, I will move to admit ABCWA exhibits 5A, 5B, 5C, and 5D.
5 Delta.
Delta.
Okay. Any objection?
No objection. I've had a chance to take a look at these. So it's 5A through 5D as in David.
Yes.
Yes, no objection to those.
5 Alpha, Bravo, Charlie, and Delta, if I know my phonetic alphabet.
Got it. Hearing no objection, Water Authority exhibits 5A, 5B, 5C, and 5D are admitted.
All right, Ms. Grinnell, could you please turn to your direct testimony, P&M Exhibit 13, at page 18?
Yes, I'm there.
At line 18, this is with respect to the Palo Verde nuclear decommissioning expenses. You state that P&M's continued participation in the 64 megawatts of PVNGS Palo Verde Nuclear Generating Station Unit 2 did not expose P&M customers to any additional financial liability, correct?
I think it goes on to say for nuclear decommissioning expense, and that is correct.
Yes. In the next question, starting at page 19, line 5, you then request to review. I'm sorry, scratch that. I might have the wrong line reference. I'm sorry, I'm correct. At 19.5, you do state that P&M should be allowed to seek additional recovery for the nuclear decommissioning expenses if it's needed, correct?
That's correct.
So could you please reconcile those two statements? If the decommissioning expenses or fund is fully funded, as has been established in past commission cases, why would PNM need additional funding? And then further, why didn't the continued participation expose customers to that additional risk?
So there's a couple of questions there. I'll try to answer them both. The first response is that we're not fully funded, first of all. In terms of the percent, we're less than 100% funded for the trusts. At this time, we are well funded, I would say adequately funded. And going forward, there may be things that change the funding status of the trust. These could be things like the estimate of decommissioning costs may increase based on a new study that may be performed of decommissioning expenses. It may be that PNM's investments in the trusts do not perform as expected and don't keep up with the requirements of the ultimate liability. So it is possible that the funding level in those trusts could go lower in the future. I think I answered your first question, Mr. Herman. Could you repeat your second question, please?
Before I get to my second question, you said that this fund was not 100% funded. Do you have an estimate on what percentage it is funded?
I can tell you how it was funded as of the end of 2022. And I do in my testimony on page 21 have funding levels as of October 31st. I can provide an update to that as of the end of the year if that's helpful. But page 21, table SGG-2 does have funding levels as of October 31st.
Okay. So my second question was, if we do need additional funds for decommissioning, how does that not represent an additional risk to customers?
Well, you're really talking about two different things here. So the ultimate liability for decommissioning is the same whether PNM extended the leases or, specifically to your question, repurchase the 64.1 megawatts in PV Unit 2. Whether or not PNM had returned those leases or repurchased them or continued them, there's no difference in the ultimate decommissioning liability. So those decisions are unrelated to the obligation for decommissioning.
Are you familiar with the I guess the lease capacity going to the Salt River project?
I am.
Are they not getting additional liability for decommissioning due to their participation in those leases?
Similar to the 64.1 megawatts and when PNM extended the leases, making the decision to return the leases to the lessors and then the sale of those to SRP has no bearing on PNM's obligation for decommissioning expenses. PNM retains that obligation regardless of how those leases are treated.
Is that because they're one of the original partners?
It's because that was how the original sale leaseback transaction was constructed, that PNM would retain that decommissioning obligation regardless of the ultimate disposition of the leases.
Moving on to your rebuttal testimony, page 8 specifically.
Okay, I'm there.
At the bottom of the page, you state that Moody's and S&P assessed various risks to PNM as a regulated utility operating in New Mexico. Is it PNM's position that they face additional risk due to operating in New Mexico?
that is the opinion of the rating agencies. And they have both stated that in numerous reports, commented on the challenging and unpredictable historically regulatory environment in New Mexico.
But they think Alabama's great. And Florida. And other states. Go ahead. Just that we've noticed some of those publications as well, by the way. and the hearing examiner did laugh, by the way, for the record. Go ahead.
I guess my question is just, is it solely due to the regulatory environment of New Mexico, or do you believe that PNM's actions and operations might also contribute to that?
I guess maybe I'm not sure I fully understand. Is what due to the regulatory environment or our actions?
Let's say the unpredictable regulatory environment. Does PNM also play a part in the regulatory landscape in New Mexico?
PNM is not making the regulatory decisions. So, PNM presents its case to the regulators, and then what Moody's and S&P comment on is the decisions of the regulators.
But if PNM were to bring, say, a application that were rejected or denied due to a failure of, their meeting their burden of proof, would that also factor into the regulatory environment that they experience here?
I'm not sure how the rating agencies would, what bucket per se that would fall into. Certainly, we haven't seen the agencies comment on, a lack of prudent applications or, well-designed applications for the commission to consider. That hasn't been part of the discussion the agencies have had when they're talking about regulatory risk for PNM.
Thank you, Ms. Grinnell. That's all I had today, and I appreciate your time.
Thank you.
And at this moment, Mr. Harris should be joining shortly if he's not already in the waiting room.
And thank you, Mr. Herman. I appreciate you contributing to a friendly, difficult regulatory environment in New Mexico.
Anytime.
Sorry, Ms. Greinel. We sometimes find some things pretty funny around
You have
here.
to have a chuckle where you can.
You do. We try. So up next, we have Walmart. Ms. Barrett, you have 8 minutes with Ms. Greinel. Is that correct?
That is correct, sir. Good afternoon, Ms. Greinel. Jocelyn Barrett on behalf of Walmart. We had reserved 8 minutes with you, but I actually do not have any questions for you. So have a nice afternoon.
You as well. Thank you.
Thank you, Ms. Barrett. Up next, we have CCAE, I believe. Is that right? Mr. DeSalen,
Thank you.
15 minutes.
Thank you, Mr. Hearing Examiner. Actually, in our second memorandum, we indicated that we had no cross-examination for Ms. Greinel. And actually, originally, we had scheduled 15 minutes to discuss with her the issue that we have deferred. So, we have no questions for her right now. Thank you very much.
I'm
thank you,
sorry.
Ms. Greinel.
I need to check that spreadsheet. I apologize. There's just
No
so much.
problem. No problem.
So, Ms. Zanazi, 20 minutes.
Can I take 7 minutes of that, and please? So I would only have 13 minutes with Ms. Greinel, and then move those 7 minutes to Mr. Phillips, please?
Yes. 17 with Phillips and 13 with Ms. Grino.
Thank you.
Is that okay with you, Ms. Grino? All right, great. All right, thanks. Please proceed.
Thank you. Good afternoon, Ms. Grino. I had the pleasure of working with you in the rate credit settlement, so it's good to see you again.
Nice to see you.
I wanted to talk to you about the 64 megawatts and really the 114 megawatts also. So it's the 64 megawatts of lease repurchase at Palo Verde, and it's the 114 lease extension at Palo Verde. You know that the hearing examiner, the commission, and the Supreme Court all held that both of those actions by PNM were made without any financial analysis and therefore were held imprudent, correct?
I am aware of the decision, yes.
Okay, and so with the 64 megawatts, there was a reduction. So as the sort of remedy to that imprudence, the commission decided that it would not give PNM their requested, I think it's called a write-up for the Palo Verde 64 megawatts, but would give it at book value, would allow PNM to have that recorded at book value. Is that right?
I believe that's correct, yes.
But the other thing that the commission held was that there should be no future decommissioning costs associated with the 64 megawatts. Is that correct?
That was in the commission's final order, yes.
But the Supreme Court said that PNM did not get fair notice because that decision was made during a commission hearing and sent it back. And that's why in this case, you are asking now to get to have the decommissioning, future decommissioning cost reinstated for the 64 megawatts. Is that right?
So just to be clear, we're not asking for any recovery of additional contributions to units 1 or 2 at this time. So I don't think it's correct to say that we're asking for that to be reinstated now.
Well, maybe not the money, but you're asking that going forward, once this rate case, once a determination is made in this rate case, that future decommissioning costs going forward be a responsibility of ratepayers, correct?
I'm not sure that I would word it that way.
How would you word it?
Let me go back to my testimony to make sure that I'm being consistent. So really what we're looking for is to continue to have the ability to ask for recovery if it's needed in the future.
Right. Okay. So on both the 64 megawatts, well, so on the 64 megawatts and the 114 megawatts lease extension, and particularly with the 114 megawatt lease extension, that would be the only remedy that the commission actually required of PNM as a result of its imprudence, correct?
I believe we started the discussion by saying that there was already a remedy imposed for the 64 megawatts, and PNM was ordered to record that at book value.
Right, but that was only part of it, right? There were two parts. And so while PNM was required to record it at book value, the commission thought, well, if one of the reasons, I mean, what they argued or what they stated in their final order was one of the reasons why PNM sought to repurchase the 64 megawatts and extend the leases was to keep on charging ratepayers for an outsized risk of future decommissioning costs. And that was discussed in both the hearing examiner's corrected recommended decision and the final order, right?
I object. That mischaracterizes the rulings in the recommended decision and the final order.
Be precise in your characterization of the rulings, Mr. Nazi, please. And if you could take it one question at a time in doing that.
So didn't the commission find that there was an outsized risk for future decommissioning costs?
I don't know.
Okay. Do you know if the hearing examiner found that?
I don't know that either. I do know that in the hearing examiner's recommended decision, they made a recommendation that if there's a shortfall in the nuclear decommissioning trust funding for units 1 and 2, that PNM could seek to recover those costs in a future rate case. That was recommended by the hearing examiner, although not adopted by the commission.
Let me ask you this. PNM retains the obligation to pay for future decommissioning, but that has not been decided by the commission, has it?
No, it has not. And that's what we're asking here, is that PNM retain the right to ask the commission for recovery of future contributions if they are needed.
PNM Resources is discussing and exchanging allegedly confidential material with its Wall Street credit rating companies. Yet the regulators and the public can't know about it. Why is that?
I object.
Where's the foundation?
Let me just ask you, is that true? First.
I'm not sure what information you're referring to, so it's difficult to answer the question.
Did you see Mr. Sandberg's testimony, specifically exhibit number 24?
I may have. Let me pull it up. This is NEE exhibit 24.
No, it's the direct testimony of Mr. Sandberg, and then there's his exhibits, and it's exhibit 1, and in there is CKS 24.
You'll have to give me just a minute to get that.
Please.
I'm sorry, Mr. Nassi, could you repeat the exhibit number?
24. It's the 2023 to 2026 long range plan. It says PNM Resources Incorporated presentation to Moody's, March 30th, 2023.
If you're using Dropbox and you wanted to scan to the PDF page, it's 259 of 304.
I apologize. I'm having trouble locating it.
It's not marked. My version is not marked CKS 24. I found the document, but it's not marked.
Is it part of his direct or his rebuttal?
It's part of his direct, the exhibits of his direct.
Okay. I think I can find it then.
Well, you have the separate exhibits and exhibit volumes, right? Mr. Nazi?
Could you just ask me that again? I'm so sorry.
No, that's okay. When I downloaded NEE Exhibit 1 into my my folders, I have NEE Exhibit 1, and then I have separately NEE exhibits 1 through 27, correct?
Correct. Yes, sir.
And what are we looking at? 24.
24.
And what page is that, Hearing Examiner Ryan, of the exhibit volume or folder?
259 of 304.
Oh, more Excel, more.
Can I just put it up on share
Yes.
screen because I'm losing all this time.
I apologize.
Here it is. Can you see this,
Yeah.
Ms. Grinell?
Yes, I can.
Okay, this is what I was talking about, and then the rest of the document. So my question is, PNMR gave Moody's allegedly confidential material, but refused to give the same information to interveners, the commission, and the public. Why is that?
I object. That completely mischaracterizes what occurred here. We did give a confidential version of this to the commission, and we reached an agreement with NEE about a public version. I assume this is the public version. And I think the question is argumentative and is also a misstatement of what the facts are.
If I can respond, this is a redacted version. There's material in here, which I agreed to with PNM because I wanted to just move on. But I'm wondering why PNM is communicating, and I don't think it's argumentative, it's just a simple question. Why is PNM communicating with a credit rating agency and telling them information that it's withholding from the commission? That's the basic premise here. And
Well, Ms. Nanazi, can I help you here, Ms. Nanazi?
Please.
If you have 2 points in time, apparently, I'm not testifying here, but apparently you discovered this document in discovery, right?
Yes, sir.
And you're saying that the company communicated information to the rating agency, right? That you uncovered, right?
Yes.
But then the company subsequently said, no, it's confidential, right?
Correct.
So why don't you lay out a sequence like that rather than try and just jumble everything into one question? You see, it's just a way of laying a foundation and going through a cross-examination, which is, didn't this happen? Yes or no? Pretty much you know the answer. I'm sorry, I don't make this a tutorial, but it does cut into your cross-examination. You know, and shouldn't, it eats into your time when we go through this process over and over again. So I'm just suggesting that I think I understand what you're trying to do. Just go ahead and do it in a more sequential fashion. I know you're trying to do the best you can to rush through because we're all limited in time. And I have that same tendency myself to want to try and, you know, collapse everything into one, but we end up in these disputes all the time because the process gets jumbled. So do you understand where
Yes,
I get what you're trying to do?
I think that you're exactly right. I had more questions, but I was running out of time because it took us 4 minutes just to even get to the document. So that's where
But
I
it-
was at.
but it-
You were
but
correct.
it's-
You are correct.
Okay. So I'm going to let you proceed. Because it took so long to find the document, go ahead and finish this line of questioning, please.
I
If
only
you
have,
ask,
a couple of
Right.
questions, but do you understand what the hearing examiner just laid out?
no, I didn't ask her the question. You have to ask
Okay.
her the question.
Initially, P&M labeled what is now CKS 24 as confidential. Is that correct?
That's correct.
And then we submitted it per the protective order to the commission. Is that also correct?
I believe that is correct. Yes.
And then afterwards, New Energy Economy and P&M came to an agreement that this document could be submitted, as well as some testimony by Mr. Sandberg, but still some of this, a portion of this remains redacted. Is that correct?
That is correct.
So let me ask you, how is it fair to the commission and to the public that there is communication between P&M and the credit rating agencies that you provide information to them that is non-confidential, but at least to some extent has been redacted for the commission? I'm trying to ask you.
Yeah. And again, I object. It's a compound question, and it's also misstates the facts. The commission has been provided an unredacted version of the hearing examiners have. And we had an agreement about.
Sustained.
How about the same question, but the public? The public doesn't get to know.
So when we're working regularly with the rating agencies, we do provide them information to help them understand what the company's projected financial position will be, as well as its business risks going forward. The rating agencies are considered sort of quasi insiders, and they do receive confidential, non-public information from the company due to that relationship. And the public doesn't hold that designation. And providing this information to the public, we believe would be detrimental to the company's position.
Hearing examiner Medeiros, I have 2 follow-up questions. Can I ask them?
Yes, ma'am.
Thank you. Can you please respond to the public's concern that P&M is a regulated entity, yet has confidential communications with credit rating agencies that the commission and the public are not privy to?
I object. There's been no foundation that the public has been concerned about discussions with rating agencies. And the question also ignores the law on disclosure of forward-looking materials.
Sustained.
Well, let me
Ask it a different way. Ask it a different way.
It's especially concerning when, for instance, I'll give you a specific example. P&M blames the commission for its regulatory decisions as opposed to taking responsibility for its own actions, like in the case of blaming the commission for impairing the marketability of the ETA bonds. How do you respond to this?
I object. P&M didn't make the decision on the marketability of the bonds. This is also outside the scope of well, it's actually not. She addresses it in her
Right.
testimony, in her rebuttal. But anyway, I guess I
Ms.
withdraw.
Grinold? Good. No, go ahead.
No, I withdraw the objection. Ms. Grinold can.
Could you repeat the question, please?
I said, this is especially concerning when PNM blames the commission for its regulatory decisions as opposed to taking responsibility for its own actions, like in the case of blaming the commission for impairing the marketability of the ETA bonds. How do you respond to this?
Objection, argumentative, and compound.
Sustained.
If PNM is communicating with the rate, strike that. If PNM is communicating with the rate credit agencies and not sharing information with the commission and the public to whatever extent it does, and then turns around and then the PNM turns around and blames the commission for the credit ratings of those agencies. How is that fair?
Same objection.
I have to sustain it again, Ms. Nanazi. I'm sorry.
Okay.
Any further questions?
No.
Okay. Let's move on then. Any questions from hearing examiner Ryan, from Ms. Greinel?
No, I have nothing for Ms. Greinel.
Mr. Alvidrez, any redirect?
No redirect. Thank you, Mr. Hearing Examiner.
All right. Ms. Greinel, thank you so much for your testimony and your professionalism. You are excused. Have a good weekend.
You do the
Thank you.
same.
Thank you. All right. Up next in our batting order.
Yes, Mr. Felsenthal, who Ms. Terwilliger will be presenting.
Can we go seamlessly, frictionlessly, or do we need a few minutes?
We'll need a couple minutes to let Ms. Greinel exit and him to enter.
All right, let's take 5 minutes. We're off the record, and then I'm going to talk to Ms. Gould now. We're off the record for 5 minutes.
I just wanted to know if Angela Pino or Sanchez was the one up on deck as we're moving quickly through the list.
I think it was Pino.
I think we have Sanchez and then Pino on our list.
Okay.
If it matters, or
It doesn't matter.
Okay.
I mean, it matters to me because I have crossover one and not the other, so I'm just curious.
Well, we're asking PNM to have on deck hitters come in, so we're going to allow them at least the courtesy there in Albuquerque or wherever of putting the order in their own batting order.
We sent out a note to Ms. Nanasi last evening informing her, and we had Pino before Sanchez.
That's what I thought. Okay.
Thank you.
Pino, then Sanchez.
I'm sorry, I had it backwards. We had Sanchez before Pino.
Okay. All right. Well, okay. So Sanchez, then Pino. Do you have that, Ms. Gould? Sanchez, then Pino.
Yes, thank you.
Sure.
Mr.
Nazi?
You said yesterday that we were going to be talking about Venture Quest number 3 this morning, and we were doing other things. And I'm just wondering when, if at all, we could have a discussion. I did ask Mr. Alvidrez if he would object, and he said he didn't, to having limited cross or questioning on Venture Quest number 3 response by Mr. Sanders. And I'm wondering, you said that at the time that you might recall him, and I'm wondering if there could be limited cross on or questioning of limited examination on Venture Quest 3.
Yeah, And there's no objection from the company?
We said it's completely up to you. We don't have an objection, but it is completely up to you and Hearing Examiner Ryan, how you want to handle that. I have confirmed that Mr. Sanders is available on Monday.
Yes, Monday, after Effington or before?
Let's get him on and off, and we'll.
Okay. All right. So Monday, 9 a.m. Sanders, and that obviously applies to all parties' ability to have limited cross-examination. I am going to ask you, though, for since I'm going to have a separate Excel spreadsheet that adds Mr. Sanders in at the beginning on Monday. How long do you estimate, Ms. Namazi, cross-examination?
15 minutes.
15 minutes. And I'll ask before I don't think this is fair to the parties to ask, but I'm going to ask the other parties if they do have any limited cross-examination that they provide estimates. Why don't you, let the parties just email the hearing examiners if you do request. And Ms. Nanazi, so that we're all on the same page on this, could you please put that in an email so that
Yes,
to remind me? Thank you. And so the same applies now to all the parties. Please email by tomorrow if you have any cross-examination of Mr. Sanders limited to PNM bench request response 3.
And sir, one other small thing. Is it possible that this bench request number 3 could be made into a PDF so it can be part of the record if you deem that it should be?
I believe we submitted it both ways.
Really? Oh,
believe so.
I might have missed that.
Yeah,
Sorry.
right. That's the perfect time to address that is Monday morning and when we have Mr. Sanders. And if you've noticed on Dropbox anticipating this, actually, if you look at Exhibit Exchange, I've added there under Exhibit Exchange. So it's the tab, 22270 this case, and then we have Exhibit Exchange, and I added a subfolder, which is still empty, but it's Commission Exhibit. So that's where that would end up. I also added a separate folder, or did I take it out? Never mind. It was just about the bench requirement. It was an earlier iteration of that folder where I had bench request responses, and I decided better just label it commission exhibits, and we'll see what ends up being admitted as a commission exhibit. But thus far, my records indicate that we have not admitted any new commission exhibits to be distinguished completely from the commission AN exhibits, which are in that separate students folder.
If I could just say,
if that makes sense.
Yeah.
I know I tend to be a didactic about this sometimes, but I make sure that I'm clear about what I'm trying to do at least, so that later on I don't hit my head and say, that didn't make any sense.
And just in response to Mr. Alvidra's statement, PNM did not provide a PDF version of attachment A to bench request 3. So I just wanted to say that. So if that could be provided at some point, that would be helpful.
Okay.
Thank you.
I
thought we did.
I have is it BR3?
Yes.
It's 2 pages, right? Attachment A.
You are
That
right.
is-
You are right. You are right.
Okay. Before I cut your cross to 10 minutes on Monday, let's move off this. So where are we? Are we with Ms. Terwilliger now? Or we have the housekeeping done? Okay. Ms. Twilliger, good afternoon.
Good afternoon. Mr. Felsenthal's in the waiting room.
Yes. Oh.
He's
It's,
not here in person. Thank you.
Yeah, I've let him in. It's difficult to keep track of the pain with the participants, and I know you guys go in and out because of trying to minimize people, but there's no chime or anything that happens that tells you someone's there. It's just you have to see it. So sorry.
right. Okay. So, PNM, would you please call your next witness?
Thank you.
We
Hearing-
are,
Sorry, go
we
ahead.
are back on the record, and we have been actually for a little while. Go ahead.
Good afternoon, Mr. Felsenthal. May the witness be sworn?
Mr. Felsenthal, will you please raise your right hand? You solemnly swear the testimony you're about to give in the matter of opinions, be the truth, the whole truth, nothing but the truth.
Mr. Felsenthal, you're muted.
There you go.
Can you say?
Yes,
Okay. Thank you. Good afternoon. Can you state your name and who you're with, spelling your last name for the record, please?
yeah, my name is Alan Felsenthal, F as in Frank, E-L, S like Sam, E-N-T-H-A-L. And by the way, the first name is A-L-A-N, bunch of different ways to do Alan. And I'm with PricewaterhouseCoopers. I'm a managing director.
Thank you, Mr. Felsenthal. Do you have before you what's been marked as PNM Exhibit 37, which is your direct testimony filed on December 5th, 2022?
I do.
Okay, thank you. Was that prepared by you or under your direction?
It was.
Thank you. Any corrections to PNM Exhibit 37?
No,
Thank you, sir. Is this testimony true and accurate to the best of your knowledge?
yes, it is.
If I ask you the same questions today, would your answers be the same?
They would.
PNM moves for admission of PNM Exhibit 37.
Any objection? PNM Exhibit 37 is admitted, having heard no objection.
Thank you. We tender Mr. Felsenthal for cross-examination.
Mr. Felsenthal, good afternoon.
Afternoon.
Where are you appearing from, sir? I only ask because, before you answer, I only ask because most of the witnesses have the backdrop that Ms. Twilliger does, and it looks like your backdrop's different.
I am at I'm at a place called Oak Park Country Club, which is in Chicago. And I had to find a room where nobody was going to come here today. So they searched and searched, and I found this place that has, you aren't seeing this, but I've got chairs and tables, and I'm hunkered in a little corner.
And trophies?
Trophy, they're not mine, but there are, I have a whole
Okay.
big room at home for those.
Okay, so you're in a suburb of Chicago,
Yes, sir.
Oak Park. Okay, I just asked because sometimes we may have witnesses who appear from other locales, and we want to establish that that's totally kosher, so to speak. We have cross-examination of you. Thank you, sir, for appearing from Chicago. Let's see. The first cross-examination would be by, I'm looking for Mr. Albright, to reserve 15 minutes with you, I believe, but he's not here. So let's move to the Water Authority, and we have Mr. Harris,
That is correct.
who's probably in Santa Fe.
That is correct.
Okay, you have 15 minutes. Go ahead, sir.
Thank you. Mr. Felsenthal, I would enjoy talking to you, but I have no questions, so I'll blessedly let you out of your little corner.
Well, I can't get out, but thank you.
Okay. Great. Up next is that's it.
None for me. No questions.
And so there's no redirect. Mr. Felsenthal, you are released, and I hope it's a good day there.
No, it's better right now. Thank you.
All right. Yeah. All right. Take care. Thank you for testifying.
Bye.
Thank you.
Bye. Okay. I like it when it goes that way for the witness and the parties.
Yeah.
Um,
It's good we
So-
did not have to travel.
yeah, true.
We've been a little worried about not having good sound, which is why we've had
Well,
folks, but yeah,
And can you imagine that in the old days when that happened quite a bit, right? It's going to be hard to go back to that way for this particular reason.
Yeah.
So if and when we do, but that'll be a while, trust me. So up next, Mr. Woodger.
is Mr. Morris. I'm waiting. He should be, I know he was waiting in the wings, so hopefully he'll come on screen shortly.
Okay.
Might not have known it would go quite so fast. So let me check.
You know that the saving grace is that, and just while we're filling space, that the witness get to come to Santa Fe. In the old days, they used to get to see the historic, the dining room or library, or what was it? It was the dining room that we had in the Palace Avenue building, the old historic building. So there was, while it was difficult to have to travel and then say, we don't have any questions for you, at least they got to travel to Santa Fe for that. But it's not, with Zoom and everything, it's just not as convenient for everybody anymore to want to do that. Okay, so we do have Mr. Morris to be sworn now.
The NM calls Mr. Morris. May the witness be sworn.
Mr. Morris, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, nothing but the truth.
Do.
Thank you, sir.
Good afternoon, Mr. Morris.
Good afternoon.
Can you state your name, spelling your last name and your title for the record, please?
My name is Larry Morris, Morris, and I am the tax director for PNM.
Mr. Morris, do you have in front of you what's been marked as PNM Exhibit 35, which is your direct testimony filed on December 5th, 2022?
Yes, I do.
And was that testimony prepared by you or under your direction?
Yes,
Do you have any corrections to PNM Exhibit 35, which is your direct testimony?
no, I do not.
Is that testimony true and accurate to the best of your knowledge?
Yes,
If I asked you the same questions today, would your answers be the same?
yes.
I move for admission of PNM Exhibit 35, please.
Any objection? Hearing none, PNM Exhibit 35 is admitted.
Thank you. And Mr. Morris, do you have with you what's been marked as PNM Exhibit 36, which is your prepared rebuttal testimony filed on July 28th, 2023?
Yes, I do.
Thank you. And was that prepared by you or under your direction?
Yes,
Any corrections to your rebuttal testimony, PNM Exhibit 36?
no,
Is that testimony true and accurate to the best of your knowledge?
yes,
If I asked you the same questions today, would your answers be the same?
yes.
I move for admission of PNM Exhibit 36, please.
Any objection? Hearing none, PNM Exhibit 36 is admitted.
I tender Mr. Morris for cross-examination.
Thank you, Mr. Williger. Water Authority, Mr. Harris.
Thank you, Mr. Hearing
Go ahead.
Examiner. There are fewer and fewer of us that remember Marion Hall, and which I have fond memories of. But at any rate, good afternoon, Mr. Morris.
I remember it often.
Good afternoon, Mr. Morris.
Good afternoon.
I have good news for you. You'll be able to start your libations on Friday easily. I have no questions on cross-examination.
Assuming facts not in evidence. So you have no questions, Mr. Harris?
That's correct.
Okay, sorry, I'm getting a little punchy here. I was punchy to begin with, but okay. Hey, Mr. Elliott is up next for the Attorney General. Good afternoon, Mr. Elliott.
Good afternoon.
You have 15 minutes?
I do. I'm sorry, Mr. Morris. I do have questions for you.
Questions are good.
Okay, thank you.
Go ahead.
Mr. Morris, good afternoon. My name is Gideon Elliott. I'm with the Attorney General's office. Would you mind turning to pages 8 and 9 of your direct testimony? Let me know when you're there.
I'm there.
Okay. You discussed the fact that it's the commission's policy to utilize a standalone method for calculating income taxes for PNM. Is that right?
Yes, that is correct.
Okay. And that's what the company's done in this case, correct?
That is correct.
Okay. If you would please turn to page 20 of your direct testimony. This is where you discuss net operating losses or NOLs.
Yes, I'm there.
And the rate making treatment for NOLs. And on page 20, so on this section of your testimony, you relates to tax benefits from operating losses that PNM has not yet been able to use in its tax calculation because it did not generate sufficient operating income to utilize those losses. Is that a correct description?
Yes, the net operating losses are driven by deductions in excess of income in prior years, primarily related to bonus depreciation and accelerated depreciation.
And these NOLs, or the net operating losses, they're treated as a regulatory asset and they serve to increase rate base. Is that right?
They do increase rate base as an ADIT asset.
Okay. PNM doesn't actually file its income taxes on a standalone basis though, right?
It files in a consolidated return with the rest of the PNM Resources Group.
Okay. And approximately how many entities are included in that income tax group?
I don't recall the specific number off the top of my head. I think it's 10 or 11.
Okay. When PNM calculates its net operating losses to reflect in rate base, does it consider only the net operating losses resulting exclusively from PNM operations, or does it also include impacts of losses in other companies in the consolidated tax group?
No, the net operating loss for PNM is just related to PNM.
Okay. So, and PNMR does not allocate any net operating losses to PNM?
No, it does not.
Okay. Do you know how much the consolidated income tax group actually paid in income taxes to the IRS over the past 5 years?
The consolidated group has not made any payments to the IRS over the last 5 years.
And the company, and that includes no cash income tax to the IRS.
Correct. So the consolidated group, because of net operating losses for the entire group, has not paid any cash taxes to the IRS in the last 5 years.
And do you recall how much PNM is requesting in this case relating to income tax expense?
For income tax expense, if you hold on just a second, I think I can get that. So federal income tax expense for the test period is 19,743,785.
Thank you.
Mhm.
If we could now turn to page 5 of your rebuttal testimony.
Just 1 second. Okay, I'm there.
I'm looking at lines 13 to 14. This is where you say that there's no indication that NMAG witness Crane's proposed adjustments to rate base take into account the related ADIT impacts. You see that?
Yes, I see that.
Okay. First, were you aware that Ms. Crane acknowledged on page 14 of her direct testimony that it may be necessary to make certain additional adjustments related to her recommendations, such as the ADIT adjustment?
I was not aware of that, actually.
Okay. In fact, Mr. Sanders, he acknowledged it in his rebuttal on page 64.
I did see it, yes.
Okay. And were you aware that Ms. Crane did make some ADIT adjustments?
No, I was not aware. I couldn't identify any of those.
Okay. Have you seen Ms. Crane's exhibits?
I did look at her exhibit for the changes to the revenue requirement.
I think that's ACC 2 in her testimony, what is called ACC COS test. Were you aware that that Ms. Sanders, that Ms. Crane basically made those changes to Mr. Sanders' exhibit KTS 3?
That she made the changes to ADIT after Mr. Sanders' rebuttal testimony? Is that what you're referring to?
Well, let me just move on and ask. So I think we can just pull this up. If you can, if you can pull up Ms. Crane's testimony, let me know when you have it. Specifically, let me see, I think it's PDF page 107, I think. It's NMAG exhibit ACC 2. So it's a part of, it's ACC 2 is the exhibit at the end of her testimony. And I think it's on PDF page 108.
Yeah, I've got the hard copy in front of me, so hang on just a second. Can you tell me the exhibit number again?
Certainly. This is ACC 2.
So
and it's
NMAG exhibit ACC 2.
And it's based on PNM exhibit KTS 3.
Okay. And then the hard copy, I don't have that, so let me see if I can get that online.
Mr. Morris, if you're in the NMAG folder, it's Exhibit 1, NMAG Exhibit 1. And I think Mr. Elliott's looking at page 108 of 125 of the PDF.
Okay, so I'm in NMAG. I've got Exhibit 1A, 1B, 1C.
One's down a little bit. Yeah, one's down a little bit from,
Oh, there it is.
yeah, there you go.
I see it.
Okay.
Just, do I have the right document on screen, Mr. Elliott? Just want to make sure I'm following along.
Yes, you do. Thank you very much, Mr. Ryan.
Yep.
So Mr. Morris, hearing examiner Ryan, if you wouldn't mind scrolling down to lines.
You want me to keep it shared? I
Oh,
can do
yes, that would be great. Yes.
Okay.
So it goes to the next page. And yes, okay. So Mr. Morris, lines 120. Regulatory assets. PVNG abandonment.
I see that.
Okay. That was one of her adjustments. 130. That's another one.
I see that also.
Deferred credits, SO2 allowance.
So if I might interject for just a second.
Okay.
So I see that there are adjustments to ADIT here, but they appear to be just excluding an amount that was in the other column, reversing those amounts. And in my testimony regarding adjusting the ADIT related to items that are being excluded from rate base, I was referring only to those, not to her adjustments, just related to taking out ADIT items that she didn't think should be included. Am I making myself clear on that? I'm not sure.
Yeah. I think I understand. I just let me just complete this and note that Ms. Crane also made adjustments to 131. Right? Did you saw that one?
I see that as well.
Okay. 139.
Yes.
Those are regulatory assets for COVID. Do you see that one?
I see that.
Okay, 141. Those are for the EIM costs. 147 was for the external legal fees for San Juan Generating Station.
Okay.
And 148, San Juan Generating Replacement Resources. Do you see that?
I see that.
Okay. So am I correct that the categories of ADIT adjusted by Ms. Crane, well, let me just go to, so I just want to make sure we got those. Okay. So if we would turn to page 6 of your rebuttal.
About a minute left, Mr. Elliott.
Okay. I just want to ask you, so let me just skip to this and just ask, can you tell me what specific adjustments of Ms. Crane you believe require further EDIT adjustment?
So as far as EDIT impacts, and let me see. Uh, And I don't recall whether Ms. Crane adjusted for the undepreciated Palo Verde assets. That's the only item that we've identified as requiring an EDIT adjustment.
Okay, our time's up. So thank you very much, Mr. Morris.
Thank you.
Thank you, Mr. Elliott. That concludes the cross-examination of Mr. Morris. Hearing examiner Ryan, do you have any questions?
No, thank you.
You're welcome. Any redirect?
Just one question, if I could, Mr. Hearing Examiner Maderos.
Of course.
Mr. Morris, just you heard Mr. Elliott, or you had questions for Mr. Elliott regarding the income tax expense in the test period. And I think you referenced that to be around 19 million. Is that right?
That is correct.
But PNM on a standalone basis, or really PNM as a group in terms of the payments to the IRS, has not made any cash tax payments to the IRS in the last 5 years. Is that what you said? Did I state that correctly?
That is correct.
Can you explain why that, why that might be the case, that the 19 million of tax expense in the test period and reconcile that to the no cash taxes paid to the IRS by PNM as a group for the last 5 years?
Yes. So tax expense is composed of a couple of items: current taxes that are current tax expense and deferred tax expense. The reason that the PNM has not paid any current taxes is because it hasn't had current tax expense because of primarily depreciation deductions and bonus depreciation deductions over the past several years. But PNM does have deferred tax expense, which represents tax expense for amounts that will be payable in future years. And that is why PNM has a total tax expense amount, even though cash taxes haven't been paid in some time.
So this isn't the case of PNM having, included in rates $19 million to customers that is not, and that $19 million is not eventually paid to the IRS. That is not the case here. Is that, can you explain that?
That it is correct that the PNM is not collecting taxes that won't get paid. They will get paid, just not necessarily in the current period, but in a future period. That's what the deferred taxes are.
Okay, that's all my. Oh, sorry, go ahead.
And no, I'm sorry. I apologize. And by current period, you mean the test period, Mr. Morris?
That is correct. Test period and future periods. Oh, do you mean won't be paid in the current period?
Which period?
That would be the test period. Yes, that's right.
Okay, thank you. Anything else?
That's all. Thank you. Thank you.
Okay, thank you. Mr. Morris, thank you very much for your testimony. Appreciate you appearing, and have a great weekend. You're excused.
Thank you.
Thank you, sir. Okay, we're at 3:08 approximately. I think we should probably take our 15-minute break before we transition to, who is it next, Mr. Williger? Mr. Sanchez?
I'm going to let Mr. Alvitras talk.
We'll be presenting Mr. Sanchez, and if time allows, then Ms. Pino.
Be a good time to take this 15-minute, our afternoon 15-minute break?
Yes, sir.
Yeah. All right, let's do that then. See you in 15 minutes. Have a good break.
Take the afternoon off, Mr. Ryan.
Yeah, that's what I was thinking about.
Is this your witness, Mr. Alvidrez?
Yes, Leonard Sanchez is going to be up next.
Thank you, sir.
Mr. Alvidrez, would you please call PNM's next witness?
Yes, Mr. Hearing Examiner, we call Leonard Sanchez to the stand and ask that he be sworn.
Would you please raise your right hand? Solemnly swear the testimony you're about to give in the matter of opinion to be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, sir.
Mr. Sanchez, would you please state your name, employer, and title for the record?
Yes, my name is Leonard Sanchez. I am Associate General Counsel and Director of Ethics and Governance for PNMR Services Company.
And Mr. Sanchez, did you submit direct testimony dated December 5, 2022 that we marked as PNM Exhibit 31 corrected?
Yes.
And were there errata filed in connection with your direct testimony?
Yes.
And does PNM Exhibit 31 corrected include all of the changes reflected in the errata that have previously been filed in this case?
Yes, it does.
And with the corrections to your testimony that have been incorporated, is the testimony in PNM Exhibit 31 true and correct to the best of your knowledge and belief?
Yes, it is.
With that, we move the admission of PNM Exhibit 31 corrected.
Any objection? Hearing none. PNM Exhibit 31 corrected is admitted.
And with that, we tender Mr. Sanchez for examination.
Thank you, Mr. Alvidrez. Good afternoon, Mr. Sanchez.
Good afternoon.
Nice to see you again.
Yes, it's been a while.
It has. So we first have up with you, Ms. Gould, I think from the New Mexico area. Is that correct, Ms. Gould?
Yeah, yes, if I could move some time.
Sure.
Can I please move 18 minutes from Mr. Sanchez to Mr. Gray, leaving me with 30 minutes with Mr. Sanchez?
Yes, please
Thank
proceed.
you. Hi, good afternoon. My name is Kelly Gould.
Good afternoon. Nice to meet you.
Nice to meet you as well. I represent New Mexico Affordable Reliable Energy Alliance, also known as NM Area. So to start out, do you support the recovery of any of PNM's requested regulatory assets in this case?
My testimony is directed at the prudence of the litigation expenses that are included in the cost of service.
Is that it? So no, you don't support
I do in, sorry, let me get to the correct page. In my testimony, I do say that I have looked at the prudence of the PNM expenses as a whole, and I do opine on as to the prudence of those expenses.
So I guess I'm just trying to figure out what questions to ask you. I was going to ask you general questions about the litigation expenses. I wasn't going to ask you specific questions about PNM's requested regulatory assets. Is that accurate, or would you be the witness to ask questions about specific regulatory assets?
I'm testifying as to the prudence of the litigation expenses.
Okay. So with that, what is the total litigation expense PNM is requesting in this case?
PNM is requesting for the test period $1,338,034.
Okay, and so that is on page 16. I had a question about that. That is on page, let's see if I get the corrected. That's on page 16 of your testimony, line 6. Is that accurate?
Let me, one moment, and I'll be there. On line 6 of page 16.
Yes.
Yes.
Okay, and so if you turn to page 1, the $1,235,964, that's the base period litigation expense, correct?
Correct.
And then how do you get from that number to the 1338034 on page 16?
I explained that in my testimony. Let me see, directly to it is we use the escalation rates that were contained in Mr. Sanders' testimony.
What, I didn't see, what is the escalation factor that you used?
It is 4% for non-labor and 5% for labor.
5% for
labor.
Thank you.
Okay, and what does the, okay, so I'm going to ask you some questions about what the litigation budget includes. Does the litigation cost include the cost for outside consultants?
It is, I actually addressed that in my testimony. Let me get to the right place here. Lots of paper. If you turn to page 3 of my testimony, beginning line 18, I described the types of expenses that comprise litigation expenses.
Excuse me just a moment. I don't see Judge Madero's on.
There he
I'm
is.
sorry, Judge. I apologize, Judge.
Thought we lost
I
you.
was off camera, but following closely, trust me.
Okay, so that still doesn't answer my question. I see where you directed me. And this might just be a difference of verbiage between different witnesses. So here you say on page 4, line 1, that it includes expert witness fees. Does that include outside consultants?
The amount that I have here is outside, is actually just the attorney's fees that are included in the 1.2 million base period expenses.
Well, it says here where you directed me that the litigation expenses include outside counsel, their staff, in-house lawyers, paralegals, expert witnesses, court reporter fees, court fees.
It would be to the, if those bills came through our outside counsel bills, oftentimes there are certain, for example, court reporter expenses are paid by our outside law firms and included on those bills, so those would be included.
Okay, what about consultants such as Ion Energy LLC?
I don't believe those were included in these litigation expenses.
Astrape Consulting?
I'm sorry. Again?
Astrape, ASTRAPE Consulting LLC?
I don't believe those are included, no.
Azar Law LLC?
I can't say for certain.
Bean and Associates?
Very likely, but I can't say for certain.
Captiva Group Incorporated?
The name again?
Are we,
Captiva, CAPTIVA.
Ms. Gould, are you talking about during the base period?
I'm just trying to figure out what PNM is considering litigation expenses. And I'm trying to figure out if what is termed consultants, if they're included. Yeah, in either period, the base period or the future test period.
I couldn't tell you specifically what consultant or expert witness fees might have been billed through our outside law firms and that were included in the period.
Okay, so the expert witness fees are only through outside law firm fees. Those would not be expert witness fees associated with PNM's cases where they have expert witnesses that are employed by PNM.
The litigation expenses that I've summarized are are a summary of the invoices that we've received from our outside counsel. So to the extent our outside counsel picked up the costs of for example, a court reporter or court fees, those would be included.
So when you turn to page 1, NMPRC litigation, that does not include in-house counsel costs.
It does include in-house counsel costs.
Okay, but it does not include in-house expert witness costs?
I'm sorry, I don't understand your question.
Well, what I'm hearing you say is if an outside legal firm picks up expert witness costs and invoices you, then it would be included in the litigation expense. Did I misunderstand you? Okay,
Wait.
so
Can I ask? I am on screen.
please.
I was just off screen here for a second, trying to deal with a little technical issue. I was listening closely, but now that we're talking about in-house lawyer fees billed to the rate case, is that right? Are you talking about, Mr. Sanchez, PNMR lawyers billing the utility?
Yes, we do allocate costs to matters.
From PNMR to PNM?
From PNMR, the lawyers are employees of PNMR Services Company.
I'm aware of that.
Yes.
And they bill PNM?
Yes, they're through cost allocation. We do keep time and they're through the cost allocation manual. In-house expenses are billed or allocated to the utility.
Just wanted the record to be clear on that.
Yes.
Same, and you also do that for in-house experts?
No, we do not.
That's where we pick up then with Ms. Gould again. Go ahead, Ms. Gould.
Okay, so PNM would have to pay its expert, does PNM pay its expert witnesses, or is that just their payment in the regular course of business, their in-house expert witnesses?
You mean employees?
Yes.
Employees are not included in the litigation to which I'm testifying as to, unless they're in-house attorneys or paralegals. And I do address that in my testimony.
Okay, but I don't know that you answered the question that I asked. Where are the costs for those employees, or those expert witness employees included? Is it just regular cost of business?
Yes, it would be cost of business, cost of service.
And they're not accounted for in the rate case expenses that PNM is requesting?
I couldn't tell you specifically with regard to that. I would assume they would be. We do, but as I said, I'm testifying as to the litigation expenses, which I define in my testimony to be outside counsel, in-house counsel, paralegals. But I do explain that other employees who assist in litigation matters are not included in the litigation expenses.
And those employees, specifically the non-lawyer utility employees, they don't bill separately for their rate case work. It's just part of their normal duties, and their salary pays for that work, doesn't it?
If they're utility employees, that's how it would be handled. And
like, let's say, not to pick on anyone, but Ms. Pitts.
Yeah, anybody who's a PNM employee is employed directly by PNM. Yeah.
And so in the ordinary course of business, their work in the rate case is they earn their keep through their salary.
Yes.
Or however they're remunerated, right?
Yes,
Okay, they don't bill separately to the rate case.
No, not that I'm
In
aware
fact,
of.
sometimes their job is full-time or part-time working on the next rate case, right?
Yes.
Okay, go ahead.
Thank you. Is there a reason that your litigation costs do not include costs for outside consultants?
We traditionally, when we put on the case for litigation expenses, we cover the legal fees, including costs that come through our outside counsel, and that's always been the way these litigation expenses have been handled.
Okay.
It's been
And
that,
then,
that way for all previous rate cases.
so the reason is just because that's the way it's been done before.
Yeah, it's
Okay. So this, in the base case, please correct me if I'm wrong, the cost for the merger case, 20-00222 UT, the cost for San Juan abandonment and resource replacement case, 19-00118 and 19-00195, they're not included in your base case.
let me refer to my so that's I know the merger case would not be included, and I addressed that in my testimony. And what other matters are you talking about?
San Juan abandonment and Palo Verde retirement.
Okay, in exhibit 5 of my testimony on page 4 of that, we do include there are some expenses related to the Palo Verde retirement, and those expenses are in-house counsel because, as I explained, the labor expenses are recovered through the cost allocation manual. So practically,
Can you stop for just a second? I'm not seeing where you are. I'm on PNM exhibit 5, LDS-5, page 404. Am I in the wrong spot?
LDS 4, page 4 of 405.
Okay, sorry to interrupt you.
No, thank you.
Okay, so is this first line application with NMPRC for Palo Verde abandonment / replacement?
Mhm.
Is that what you're referring to?
Yes.
Okay. And do you know that PNM is also requesting a regulatory asset for that case as well?
Yes, I'm aware of that.
Okay, and where in the am I good?
Yes.
Where in the application is it shown that there's not a duplication between this accounting and the regulatory asset?
This is, as I was explaining, we're talking about the scope of my testimony is about the prudence and litigation expenses that we incur. And this is, these expenses right here are for in-house counsel, which are allocated through the cost allocation manual. And so these are, we allocate annual labor expenses through that methodology. And so in order to better reflect the litigation expenses that we would incur during the period, we have included the in-house counsel expenses for that reason.
Okay, and so what I am gleaning from your answer, even though you didn't say this, is that the regulatory asset would be for the out of house counsel?
Yeah, it would be the other expenses because, as I said, the in-house counsel are recovered through the cost allocation.
Mr. Medeiros, did you have something? I saw you raise your hand. I'm sorry. And then to go back, I'm really just kind of confused on what's in and what's out. So now I'm back at page 3 of your testimony, and you say that the litigation expenses include outside counsel.
Yes. Or
But not for.
no, but if what I say is that I also clarify in my testimony is that on page 1 of my testimony, beginning on line 10 and continuing through, I state that I'm addressing the prudence of various categories of litigations incurred and booked.
I'm sorry, categories of litigation.
Expenses in the cost of service. So deferred matters aren't, since they're not included in the cost of service, they're not covered in my testimony.
And did you make that determination?
That's how litigation expenses have always been presented in rate cases.
Okay, so page 3, lines 8 through 10 of your direct testimony, you cite 17.9.530.7 as in Peter, NMAC. You state litigation means all contested matters before regulatory commission administrative bodies. Is that accurate?
Okay, you're on page 3. I'm sorry, where are you?
Oh, I'm sorry. For some reason, my lines 8 through 10, you're
Okay.
citing Rule 530.
Yes.
Litigation means all contested matters before regulatory commissions, administrative bodies, arbiters, and state and federal courts. Is that accurate?
Yes.
So if that's what's required by Rule 530, why does PNM not include all of its litigation expenses in its request?
I do, because we're breaking out the cost of service expenses. We break out the cost of service expenses. I have looked at litigation expenses generally, including for the deferred matters, to determine that they follow the same processes and procedures to ensure that they were prudently incurred.
But in 530, it doesn't make that distinction that you're making. It says all.
And as I said, I have opined as to the reasonableness and the prudence of the litigation expenses, both in the cost of service and to the other matters. I didn't detail them out in my testimony, but I have reviewed the matters and determined that they were subject to the same processes that we use to determine the prudence of those expenses that were incurred.
Yeah, so my issue is more about if Rule 530, in my reading of it, it requires PNM to make a litigation budget. And so if you make a budget, shouldn't the commission require you to stick to that budget and not continually request approval after approval of regulatory assets for litigation expenses?
Those in the rate case, they don't pass on those expenses. Those are deferred expenses addressed in those later cases. So it doesn't. For that reason, we address them in those cases because they're not addressed in this case.
I don't think you're understanding my question. Rule 530 requires you to estimate all litigation expenses. To me, that means it's requiring PNM to make a budget for the future test year. Okay, are you following me?
Okay, so could you refer to me where in Rule 530 you're referring to?
Just the same place you quoted, 7P.
Okay, and I'm trying to find where you say we're supposed to prepare a budget.
Well, what I'm concerned about is all the regulatory assets. So what I'm trying to figure out is how PNM budgets its litigation expenses. And if it creates a budget, if it creates an estimate to the commission of this is what's going to cost us, we're preparing a future test year, shouldn't it be required to adhere to that, to what it puts forth to the commission? This is
We
what
are-
it's going to cost us.
In the rate case were those deferred matters. I'm talking about the matters that are included in the rate case, which are the cost of service. So we do address those matters, but for deferred matters,
But there were, can I just interrupt you? When you did you've done this before in a previous rate case, right? So you would create a litigation expense in whatever the past rate case was, 15261, right? And then why aren't those deferred matters already included in the base rate, the base rates from when you estimated the litigation expenses in the last rate case?
I'm not sure I understand your question.
Did you estimate litigation expenses in 15-261?
We did, as in previous rate cases, we have estimated litigation expenses that would be included in the cost of service.
Okay, so then why are there all these cases that PNM has been asking regulatory assets be made if litigation expenses are already in the cost of service?
Because they're not necessarily the same expenses. We're recovering for the annual, the costs that we would expect to incur during the test period. And any other costs would be covered in those other cases.
I don't understand
Part of
your
the
answer.
regulatory-
Aren't you supposed to be making a proposal for a future test year and then those rates are set regardless of what the actual costs are?
Yes. And
Okay.
these are projections of what our actual costs will be during that period.
So why shouldn't PNM be required to stick to what its projections, what it projects its litigation expenses to be?
Well, they're, as I said, those were costs associated with those particular assets. And so we're seeking recovery as part of those assets.
But that doesn't answer my question. Why shouldn't PNM be required?
Because we've deferred those expenses from prior years, so we have to recover them at some point.
Why do you have to acquire them at some point? They're just a wash in the regulatory lag.
They're the cost of doing business. So we either recover them through the cost of service or through the deferred assets. It's the cost. It's their actual costs that we've incurred.
Okay, I'm going to move on. I have a question about the merger case. That's a known cost, right? That we know that there's going to be a merger case coming up next year. Is that accurate?
Yes.
Why isn't that in PNM's litigation estimate for the future test year?
Because we're not seeking recovery of those costs. And I explained that in my testimony.
So when the merger comes, you're not going to ask for a regulatory asset of those costs?
For litigation expenses, certainly not.
Okay.
Did you just reveal new information about the new merger case? Or am I behind on the news?
I was merely responding to the question I received.
That matter, can we hold a hearing Friday then? Is the oral argument canceled in that one too?
As I said, I was just responding to the question that if
Oh, come on, Mr. Sanchez, you're talking to me, okay? You're talking to me. I could ask you a direct question. I won't, but just don't,
No, as I said, I'm just,
Well, no, let me ask you then. Is there been announcement of a merger filing? Who knows what that merger case may be? It may be with Avangrid. It may be with Florida Power and Light. Who knows?
But as I said, if I was presented with a hypothetical, if there was a.
Was it a hypothetical?
Well, if you're talking about past expenses that we've incurred with regard to the merger, we've said we will not seek recovery of those expenses.
It may be my hearing or my synapse is not firing because I thought you said merger proceeding next year. Did I miss?
I was, as I said, I believe I was just responding to Ms. Gould's question.
You really stick to your answers, don't you, Mr. Sanchez? Now I'm starting to get a little annoyed, frankly. You're
Okay.
starting to see a little of my Portuguese. Come on now.
I
Is there a merger proceeding coming up next year? Has there been
I-
discussion of that with anyone?
as I said, I was responding to a hypothetical that was.
I'm disappointed, sir. I'm disappointed. Okay? Slick. Well done. But not with me. Noted. So maybe that's why you didn't say, nice to see you too. Perhaps you're having a flashback. Anyway, go ahead, Ms. Gould. I'm going to go off screen for a second.
Okay.
That was for effect. I'm back with a smile. Let's go. Let's
I
go on.
appreciate it.
Okay,
Well, we need a little comedic. Okay, feeble attempt
It's,
at
it's
comedy.
Friday
all
after, it's
right?
Friday afternoon. I certainly.
Feeble attempt at comedy, but it's frustrating sometimes because you are sticking to the script, frankly. Go ahead, Ms. Gould.
page 11, you state, I looked at the process and mechanisms that PNM Law Department has developed to control
Sorry.
litigation.
I'm sorry,
Sorry.
you'll have to slow down and start again.
Sorry. Page 11, you state, I looked at the process and mechanisms the PNM Law Department has developed to control litigation expenses. Those processes are to reduce fees. Is there any, what about reducing litigation? Is that part of the control?
Well, certainly, we do have preventative law processes in place. We regularly counsel our business people on preventative law measures, and as I said, we have various processes in place to ensure that the litigation expenses that we incur are reasonable and prudent. We have an outside counsel policy. We have multiple levels of reviews of invoices and such, all to ensure the expenses we incur are prudent.
Does PNM make a overall litigation budget?
We do budget for it. We do have law department budgets, and it does have some. It does break down by different categories and such. It's oftentimes litigation is difficult to predict, but we know as we do here that there's a certain level of litigation that we'll have each year.
And on page 12, you say, in seeking to control PNM's legal expense, in-house counsel aggressively negotiates reduced legal fees with outside counsel. Can you tell me what the average hourly rate PNM pays its outside counsel?
I couldn't tell you across all the firms. I know generally.
A range?
The range is as from roughly from about 160 to, in some specialty areas, as high as I think over $1,000, but some of those are driven by other factors such as insurance carriers who are involved in our matters.
Ms. Gould, I've added 2 minutes to your time, given my failed stand-up routine. I'm penalizing myself.
Thank you.
Sorry, Mr. Sanchez.
What about for these NMPRC proceedings? What's the range for that kind of specialty?
It would be from around 200 to around in some specialty areas around 700
Per hour?
per hour.
Are you aware of any jurisdictions that require utility stakeholders to share in the costs of litigation expenses?
I'm sorry, could you repeat that?
Are you aware of any jurisdictions that require utility stakeholders to share in the costs of litigation, of the utilities litigation expenses?
I'm not sure what you mean by sharing in the cost.
Well, these costs are passed on to ratepayers, are they not?
It is part of the cost of doing business, so it is factored into our rates.
So are you aware of any other of jurisdictions that require shareholders to pay part of those costs?
No, I'm not.
Okay. Would you think that would be a proper control on the utilities litigation spending?
No, I think the controls that we have in place are adequate and ensure that we incur reasonable and prudent expenses.
Are you aware of any jurisdictions that limit utilities' ability to record regulatory assets?
I am not.
Are there commission guidance on when a utility can record a regulatory asset?
I'm not an expert on regulatory assets.
All right, thank you. That's all I have.
Thank you, Ms. Golden. Again, apologies for my interruption.
No worries.
Can I ask a
Thank you
few
so
follow-up
much.
questions from Ms. Gould? Like to,
Of
if I
course.
can. Mr. Sanchez, how are you, sir?
Good, Mr. Ryan. Nice to meet you.
You as well. As I was reviewing the testimony in this case, Miss Andrea Crane for the New Mexico Attorney General, she at one point notes that the hourly rates for the attorneys engaged in this case, meaning 22,00270, appear high, with rates up to $700 per hour, and that's her direct testimony that I'm reading there. And I remember when I read that, I said, well, that is high. As far as I'm aware, in my world, that's pretty good. Be good work if you could get it. Sounds like what you're telling Ms. Gould is also that with the litigation expenses that are not related to this rate case, you do also have folks who are being reimbursed at that level, that hourly rate.
I'm sorry, I'm not sure what your question is.
Do you have, you told Ms. Gould, so when I read $700 an hour for this rate case, even Ms. Crane, and I'm not the one generating the, she said it, like that's a lot, right? I'm just saying, yes, I agree with you, Ms. Crane. But now you're also saying, and I didn't see this in your testimony, that the folks that you pay for other litigation expenses, which is, as we know, you've made clear that does not include this rate case, your testimony, they're also compensated at approximately that level. I'm just asking you to confirm that's what you told Ms. Gould.
I didn't personally speak to Ms. Gould, so I'm not quite sure what you're referencing.
Okay,
I apologize.
let's ask it this way. No, that's
I'm
fine.
Ms. Gould.
No,
I think, yeah,
I'm,
so I think
sorry. I'm sorry.
that's okay. I think that,
I'm
yeah.
sorry. I got.
If you thought I was meaning Ms. Crane, no, you
I
just
was
had a
thinking-
discussion. Yeah,
I was thinking of, I had Ms. Crane in mind. I'm sorry.
that's
Ms. Gould,
okay.
I
You
apologize.
just told, here's what I can tell you just happened, because I watched it.
No,
You told Ms. Gould, in our litigation expenses, we have folks, we pay up to $1,000 an hour for specialty services. Is that
Yes.
true?
yes, it
You
is.
said those words. I'm sorry, I keep talking over you.
Yes.
Okay. Did you provide to us in this, in your testimony, any place, a breakdown of, who's getting paid and what amount of hours so that the commission would even know that that's happening?
I have not included that in my testimony.
You will now, bench request 6.
So what?
An itemization. The commission wants an itemization.
I mean, it just seems, Ms. Gould's line of questioning is patently reasonable, right? It's, what are these expenses? How are you budgeting?
Who is reviewing these and authorizing these?
And then not only that, but I think her broader point is also, if you've got a budget, well, you got to stick to it. And it's not unlimited legal expenses, because if you can come in after and get a regulatory asset for the cost, well, then you never really needed to do a budget in the first place. I mean, that's her point.
And that's not what I testified to. I said the items that we have itemized are those that are included in the cost of service. And
And where are they in the record?
where in my, I have it in my, throughout my testimony, including the tables. I have the expenses for the base year, and I've escalated those using the cost the escalation factors included in Mr. Sanders' testimony, the 4 and 5%.
That's not what we're asking, sir.
Okay, I'm sorry, I misunderstood.
Go ahead.
So, yeah, no, so
Ryan.
let
You
me
could ask
understand.
better than I.
No, that's okay. And I just want to understand your answer there, Mr. Sanchez, because I'm not trying to tell you, I'm just telling you what I heard in your exchange with Ms. Gould. And so if you need to clarify for me something that I'm misunderstanding, and I'm eager to have you do that. So when you say the costs for the cost of service, and this I presume would be the itemized tables that accompany your direct testimony, is that what that is?
So the items that are in the tables are for the base period, and we use those to estimate using the escalation factors to determine an amount for the cost of service during the test period.
Okay, I understand. And so then, if there are legal expenses that your company incurs, well, let's ask it as an affirmative question. Do you incur legal expenses throughout the course of a year that are not built into the cost of service?
Yes, and I do cover that in my testimony.
Where do you cover that?
For example, there's some expenses that aren't allocated, that for which we, let's see.
Don't forget about bench request 6, though.
Yeah,
Okay.
no, I just want to make sure we get clear on what we want to know before we.
Okay, so beginning on page 6, line 21, there's a question about, are there litigations not included in base and test period? And it's yes, litigation, and I explained there what is not included.
Non-litigation legal expenses. So that's a legal expense for not, what is a non-litigation legal expense?
Contracts, other types of right-of-way work.
Oh, okay.
Things like
Transactional work, okay.
Transactional.
And other non-case related legal work, right?
Yeah, yes.
So is this where, you know, Ms. Gould asked about the merger expenses, and then that resulted in the conversation about whether there's another merger case coming. But I mean, would you then, would that type of an expense fall into this category of legal expense? Or is that something also different?
We, as I said, the merger expenses, we were not seeking recovery of the litigation expenses associated with the merger.
Okay. Well, let me ask you this then. Are there other legal expenses you incur that are not non-litigation legal expenses that are also not as part of the cost of service projected to the future test year?
In other words, expenses for which we won't seek recovery.
Or expenses that you'll seek to recover through a regulatory asset?
There are expenses that are deferred as part of, and are part of the regulatory assets. And there are certain expenses that we have, for which we have chosen not to seek recovery.
And you've been consistently parsing those. So I don't want you to lose track of the site that we're asking for an itemization of those that are subject to the regulatory asset part too.
Yeah, and I guess what the real question is, even Ms. Gould seems to be driving towards, is like, okay, how do you decide what is a deferred legal expense?
Because if it's part of a case that's for which a regulatory asset was established.
Well, how do you decide whether a case should or should not be a thing for which a regulatory asset is established?
I'm sorry, I don't. I couldn't specifically answer that.
Can I ask you about the decoupling proceeding and the decoupling appeal? Is that a deferred expense?
Let me see if I,
And if I'm making headway on amplifying on the bench request, that's all to the good.
let me see if I,
Go ahead, Hearing Examiner Ryan.
No, he's looking at, I'm happy to have him. I mean, I think we've kind of gotten to a point where we've exhausted this. In the sense of, I mean, I don't know that I feel any clearer on much, but I have lots of questions. And I
Well,
won't
we need-
stall
well,
out. Yeah, I don't want.
Apparently we need to keep poking
the
away.
coupling expenses are included in my exhibit as expenses for which were that are included in the cost of service.
That are included.
Yes.
Okay. Could you give an example of a deferred, the merger proceeding, is that deferred?
No, it is not.
That
It's in
one
the
you
cost.
just, that's
We are not-
out.
That's out.
That's
That's
just
out.
out. And,
Yeah.
and why is that out? Just because that's, I mean, you know, is that a requirement, or is that like a discretionary determination, or that's just the company felt like, well, that's the appropriate thing? I mean, who decides that?
It typically, when you're going through merger transactions, those type of, the costs of the transaction are not recoverable. And so it's how it's handled in these cases, or in regulatory matters.
So I guess what yeah, go ahead, Mr. Madera.
No,
it's
no.
fine.
So if it's in the cost of service, like the decoupling proceeding, is there an itemization of the hourly rates of the attorneys and potentially the experts, if any, that testified? I don't recall. No, there was no testimony, actually. It was just attorneys making oral arguments. So is there an itemization of that somewhere in the record?
We don't, what I've done is I've given in my exhibits, the costs for outside counsel and total cost for outside and inside counsel for those matters that occurred during the case period.
So is there an itemization of those costs?
In my testimony, no, there is not.
Okay, so that's part of bench request 6. An itemization of things that amplify on and inform your testimony, both with regard to your who are you looking at?
I'm just, I'm trying to.
Do you have someone else in the room with you?
I just have somebody who's handing me exhibits.
Okay.
I'm just.
Okay.
They just hand me exhibits, so in case I need something off the shelf, I don't know where it is. There's a lot of notebooks in here.
Yeah, there are, I'm sure. Are there windows in that room that you can
No,
look
there
through?
are not. No, there are not.
Okay. All right. So that's one set. We want to see an itemization, because who's reviewing the charges? The month you get monthly statements?
We get monthly statements. We go through several levels of review. We require that all our outside law firms bill through an e-billing system, which first determines that all the billers are authorized to bill on the matter. If there are anybody who has billed to the matter who has not been previously authorized, their time and any charges that they've billed to the matter are flagged and will not be approved until they're cleared. So there's built within the software, there are the first check. We also have, so if there are any exceptions that are it goes to our law department administrator, who takes an initial look. And typically we go through a third level with paralegals who take a look at the bills to make sure that the entries are correctly allocated or correctly billed to the right matter, and they don't, and if there was anything unusual about them. And then they go to an attorney for further review. And in some cases, they go to a second level attorney for further review.
Why would they go to the second level?
For example, if one of the in-house attorneys is a lead on a particular matter, but another in-house attorney is working on the matter with outside counsel, they'll want input from that attorney since they most directly worked with outside counsel. So we're trying to ensure that the people who are most knowledgeable about the work being performed are involved with the review.
And are bills ever adjusted
Yes,
downward?
yes.
Okay, well, so part of bench request 6, I'm still struggling to develop it with you, and I'm sorry for that, but it's the itemization of in your tables, you have, as I understand it, total numbers for the matters, but we'd like to see a breakdown. Here, help me out here, Hearing Examiner Ryan, if I'm getting this right. A breakdown of an itemization for each of the matters.
I think yeah, to get to, and I think what the point of it is, and I think you understand where this all was generated from, was a sense of, you know, what are the costs of these professional services? How much is being expended? And, you know, just to give the commission assurance that professional services are often understandably expensive, but, you know, $1,000 an hour is a lot.
And frankly, the ratepayer is entitled to the information as well.
Certainly, but
you would agree the ratepayer is entitled to the information as well.
As I said, we take steps to minimize costs because we do have the ratepayer in mind.
Yes.
There's no incentive for us to incur higher costs with outside legal.
Well, that's what generates the question. So just, you know, as you're supplying us more information, understand that that's the nature of the inquiry.
No, I appreciate that. Thank you.
And we're just doing our due diligence as well, just like you do your due diligence.
Yes.
We want to understand the process. Having conducted that process myself in a prior life, I understand how difficult it can be at times. The particular one you're endeavoring to do. So that's one category or bucket of costs, if you will, and itemization. And then there are the deferred costs, the deferred asset, if you will. Is that your responsibility as well in your testimony?
I do say that the other categories of litigation expenses are prudent, so.
I just personally, what I would like is a more clear statement of exactly how one goes about determining that something is a deferred cost, and then it may be very useful even to PNM for us to have clarity about that, and to Ms. Gould too, who's still looking on intently.
We can start with you categorizing what's a deferred cost and what isn't, and then providing if it's not too burdensome, an itemization and the separate buckets, if that will help clarify. I don't know whether it will.
Or even if you have to supply some minimal supplemental testimony, here's how the company determines what is a deferred legal expense, and here's how it differs from a cost of service expense, and this is the process. I mean, that's pretty bread and butter.
Unless you've already provided that testimony. I'm sorry. Sorry for stepping over.
No, as I said, I tried to explain, I'm testifying as to the prudence of legal expenses, not other matters. So that's somewhat beyond me, but I appreciate it.
No, well, this could be part of our understanding the prudence of the legal expenses. How about that?
Absolutely.
Okay.
Thank you.
Do we need additional testimony here, Examiner Ryan?
I think I said that's what I'd like. I mean, I just need to not have this question answered. I don't know how I would go to the commission and say, well, there's this discussion about legal costs, but there's this thing called deferred costs, and no one knows what they are or how they're determined. I can't say that. I mean, I know that I'm exaggerating here, right? But that's frankly, put yourself in my position where Mr. Maderos and I have to then explain to the commissioners who are all intently paying attention and will want to know the answer to this. As we can anticipate, there will be exceptions within, not exceptions, but this is going to be part of briefing. Mrs. Gould has brought this up, so we know this is going to happen.
Mr. Alvidrez wants to interject. Go ahead, sir.
Yes, if I may get a little clarification.
Yeah.
And I don't know if you want testimony, that is certainly your prerogative. I think we can explain it in a bench request, and I'm not sure that Mr. Sanchez would be the only one providing supplemental testimony. Mr. Sanchez does address in some detail the regulatory assets, and that's really what we're talking about in terms of deferred expenses.
Why don't we try a bench request?
Okay.
That's obviously subject to the rule that we request cross-examination of the appropriate witness.
Okay.
Potentially, maybe not. Maybe the bench request response will be illuminating enough.
We hope so. And then in terms of the itemization, if I could just get a little better idea. So if we could look at PNM exhibit LDS2.
On it.
And the very first item is SJGS Sierra Club RCRA RECRA.
Right.
And as base period litigation expense, there's a figure of $8,908.12. Is what you want an itemization of what comprises that number?
Without thinking of a reflexive answer would be yes. That might not be the best answer though. Hearing examiner Ryan?
Yeah, I mean, the goal here is not to make the company do endless work to produce something that's not going to help. The reason that the question came up and asked is to try to understand how much professional services are contributing towards this 8,900 number. So for instance, was this 1 hour, if this was 1 hour of work for a person paid at $8,900, obviously I'm not suggesting that's what's going on, but I'm just using that as a sort of an absurd hypothetical. I think you can discern from there, like, what is it that you think we'd be interested in? So I don't know how you structure the answer exactly, but I just would say that this whole discussion was generated by concern for how much is being expended on professional services. And I think there's ways to answer it that doesn't require you all having to do endless work.
Well, I mean, that's one way for us to cabin it. And if I understood hearing examiner Maderos' request, what he was asking for on the reg assets that include legal expenses.
Yes.
He wanted an itemization of the legal expenses that are included in the reg asset, if I'm correct about that.
Yeah. Yes. And this is going to, I can see that this is going to take some time to put together. Is that fair to say?
I don't know. I think it will take a little bit of time, but
yeah.
Not,
Okay.
beyond the hearing or anything like that.
Okay.
Mr. Hearing Examiners, I have a question regarding these bench requests. PNM had its opportunity in its base case to make its record on these regulatory assets. And if they didn't prove them up, we've all filed direct testimony and rebuttal testimony. If there's not enough evidence in this case for the commission to approve those regulatory assets, I think we would object to giving PNM an opportunity to put additional information in this case that the parties do not get the chance to address.
Overruled. You already heard hearing examiner Ryan. And you've heard me say this many times before, going back to when you started. I have to ask the questions that I think the commissioners might ask of me. Hearing examiner Ryan, no, not one more word. Overruled. You heard hearing examiner Ryan give exactly the same sort of observation that I've given many times. May sound off the wall, but we have to ask the questions that the commissioners may ask of us. We have to anticipate those things. And that's where a lot of these bench requests come from. Some of them, hopefully. Others may be, even more precise, but the objection is overruled, as if it hadn't ever been asked.
Well, I would like to lodge the objection for the record. Thank you.
You already did. You spoke. Off the screen. Good. Have a good weekend, Ms. Gould.
Mr. Hearing Examiner, as though it was
You
never
are off.
asked. No, I am allowed to make a record, okay? I
You made
appreciate
a
that it's
record.
late.
You're
but you
arguing
said
with
that-
me. Goodbye,
No,
Ms. Gould. You're off
Your
for
Honor.
today. We'll see you Monday. Off.
I do not appreciate to be talked this way, okay? I do not allow my family members or my son to talk to me this way. I'm allowed to make my objection for the record. You said as though it was never asked.
And I don't allow my family to argue with me the way you're arguing with me either. Thank you very much.
I feel like I'm being very respectful, Your Honor.
Have a good weekend, Ms. Gould.
Thank you. I will stay on so that I can hear the schedule for the upcoming week.
You can. Okay, let's get back to the bench request.
Yes, sir. We can explain what legal expenses, the distinction between cost of service and deferred legal expenses. And again, we can provide an itemization of what makes up the numbers in the exhibits in Mr. Sanchez's testimony, and we can provide an itemization of the legal expenses that make up the regulatory assets to the extent that they do include they do include legal expenses.
Okay.
They may not be litigation expenses within the definition, but you'll see what the hourly rates and the number of hours that are incurred, if that's acceptable to you.
Hearing Examiner Ryan?
Yeah, I think that's fine. And I suspect this is going to be one of those ones where we're probably going to have an opportunity to discuss this again throughout the course of the proceeding. So I don't think we have to have it all exactly hammered out right now. This was a starting place, let's say that. And for the bench request, and you can supply it, and then other questions will, I'm sure, be generated based on the response. I have to, I personally have to take a break for biological reasons. I'm sorry.
No.
I am a massive tea drinker and I consume a lot of it, and then I'm Irish, and that's what happens. So I must take a break. So can we please, just for 5 minutes, and I do that for Mr. Lee's benefit as well.
Let's take 10. We're
Okay.
off for 10.
Thank you.
Oh, all these people are in it. They're just not up.
Judge, if you're talking to us, you're on mute.
No, still muted. You might just select the right mic, that thing.
Hear me?
There
I
you
think
go.
you can hear me now.
Yeah.
All right.
Yeah.
Okay, apologies. We're back from our break. Let the record reflect that Ms. Gould was allowed to remain in the hearing. The hearing examiner erred when he said as if the objection had not been, the hearing examiner, me, erred when I said as if the objection had not been spoken. That allowed Ms. Gould to continue arguing with me, which was also an error. But be that as it may, the hearing examiner caused the error by saying as if the objection had not been spoken. However, from this point forward, let's all refrain from personalizing statements in a way that is unbecoming. Is that understood? Ms. Gould? Personalizing statements?
I'm not sure what you're talking about.
Okay, you're gonna play it that way?
I felt like you were talking to me very inappropriately.
And you
we don't-
spoke just inappropriately back to me.
I
Continuing to argue.
apologize. I apologize if you felt like my presentation was inappropriate.
That won't work if you felt. The record speaks for itself, Ms. Gould. Thank you. This disruption could be taken out of your cross-examination going forward. That's taken under consideration. Thank you, Ms. Gould. You shall remain on screen for now. And that's how I feel. All right. Cross-examination of Mr. Sanchez. Bye. Who's up next? Mr. Harris. Good afternoon, Mr. Harris.
Good afternoon, Mr. Medeiros. And good afternoon, Mr. Sanchez.
Yes, Mr. Harris, it's been many years.
Yes, it has. I was going to comment on that I'm sure we've met in the past because we've both been sort of long in the tooth. And one of the first questions I was going to ask you, did you observe Mr. Herman making any of his cross-examination?
I'm sorry, his cross-examination of which witness?
Particular witness. The only reason I'm asking is because in his office, he has on the wall 3 guitars.
Oh, yes, I did see him earlier today, yes.
And my comment was going to be is that those guitars were to accompany him as he did his song and dance a la Chicago. And since I don't have those guitars, I won't take as quite as long on my cross-examination.
Okay.
My first question is to the scope of your testimony. I believe you've told us that you're testifying about the prudence of the witnesses, but you're not the legal expert on how they accounting for that, for those expenses. Is that correct?
I'm sorry, could you repeat the question?
Yes.
Mr. Harris, you're kind of fading in and out.
Okay. Maybe I'll get closer and that'll help. I won't look away. While you're the expert on the prudency of costs, you're not, it's my understanding you're not the expert on the accounting for those costs. Is that correct?
Do you mean, when you say the accounting, are you talking about whether they're deferred or in the cost of service?
Well, yes, and how they're treated on the books and records and in the cost of service.
I'm testifying as to the prudence of the litigation expenses, but if you're asking for the accounting, I'm not the expert.
Okay, and that was what I was driving at. Okay, then my next question is, are the costs for the San Juan settlement, the legal costs for the San Juan settlement, are they included in your exhibits as a test period cost?
No, the test period cost is a projection based upon the types of costs that were incurred during the base period. So in that sense, they are not.
Are you familiar with the terms of the settlement, of the San Juan settlement?
Generally, yes.
Okay, and generally, are the legal costs to be included in this case?
No, my understanding is that we would not recover the legal costs incurred in that matter.
Okay, that's my understanding as well. Thank you. Turning to your testimony at page 1.
Yes.
Okay, and on this page you have a table 1 that shows categories of litigation categories, basically 5, correct?
There are 4 categories.
Oh, okay. I missed that. And the reason I guess I missed that is because I thought that there were, I just miscounted. Well, it's 2 through 5 are the exhibits, so there are 4. Thank you for that correction. So, and that was my follow-up question, that those categories that are shown there appear as exhibits to your testimony, and the exhibits would be 2 through 5.
Yes.
Okay. So turning to exhibit 2.
I'm sorry. Bless you.
Okay.
Thank you.
You're there?
Yes.
Okay. And exhibit 2 is tort litigation expenses. And this exhibit shows case descriptions and issues, correct?
Yes.
Now, it's my understanding upon review of that these litigation expenses for torts cover a wide variety of torts, such as negligence, trespass, wrongful death, and billing error, correct?
Yes.
Okay. And then I'm going to ask the same question regarding the next exhibits, that these exhibits show that there's, under a particular category, there is a wide variety of costs under a particular category. That's correct?
When you say a wide variety of costs, you're talking about a variety of cases, or?
Well, yeah, and in my example about the torts, you have litigation of various types of torts. And for example, in your exhibit 3, which are human resource litigation expenses, there's various types of human resource litigation, which would include, for example, overtime, bypass, forced terminations, et cetera, et cetera.
Yes.
Okay, and that's true for all 4 of your exhibits, that these categories include a variety of different types of legal cases.
Yes.
Okay, and that's all I wanted to point out. Thank you for your time. I appreciate your testimony. Mr. Hearing Examiner, I'm through.
Thank you, Mr. Harris. Attorney General.
Thank you, Mr. Hearing Examiner. Good afternoon, Mr. Sanchez.
Good afternoon, Mr. Elliott. Nice to meet you.
Many of my questions were asked by the hearing examiners, but I have more questions. So let me just start with this. So how big is the law department at PNM?
We have 6 in-house attorneys.
And the same question for PNM Resources?
That includes all of the attorneys across the entire company.
Okay. And are you involved in picking teams of attorneys?
When you say picking teams of attorneys,
for instance, this rate case, were you involved in deciding which attorneys would work on this case?
no, that was left to our lead regulatory attorney.
And just for the record, that is?
Stacy Goodwin.
Okay. Who at PNM approves the bills?
I explained that in my testimony. Let me see. Well, let me get to my testimony. That it is the responsibility of in-house counsel to ultimately review the bills, but we do seek input from the business people where it's appropriate.
Okay. Okay, so here now my new question. So if you could go to the exhibits that Mr. Harris was just looking at. I think it's LDS 2, starting at LDS 2.
Yes.
So just the file number, that's an internal tracking number?
Yes, it is.
Okay, so we don't have the case numbers for these matters that are listed. Is that right?
No, we have not provided those.
Okay. And then I see that there are codes such as LIT and TPA.
Yeah.
Can you explain to me what those mean?
The LIT is litigation and TPA is third-party administrator.
Is that, does that mean an outside counsel or?
Yeah, we for tort litigation, for smaller tort litigation, we work, we have an in-house counsel who's oversees all the litigation and works with a third-party administrator similar to what an insurance company would utilize for that type of tort litigation to help manage the litigation, ensure that things are run appropriately and that the expenses are prudent.
Okay, we're not talking about like arbitration. Okay.
No. There-
And when you had mentioned the hourly rates of up to $1,000, you had, I think, mentioned it in the context of insurance.
Yes.
Can you expand on that? Explain?
Well, in certain cases that, we obviously carry an insurance for tort litigation or other matters like that. And oftentimes the insurance companies have input on the counsel that we retain, because we will get above our retained limits. So we consult with them, and oftentimes they will recommend an attorney with a particular specialty.
Okay. So there's one of these items here at the end of LDS 2, tort litigation expenses. You have McBride Fire, CCMSI investigation. What does CCMSI mean?
I apologize. I can't recall exactly what the acronym stands for.
Well, let me ask this. Obviously, given the seriousness of that fire, is this the type of litigation that would be disclosed in an SEC filing?
The SEC filings, it depends because we have insurance that covers it. So even though the ultimate exposure could be, we've certainly received demands in large amounts. The determination for inclusion in the SEC filings includes whether we have insurance for it, because the actual exposure of the company may be much lower because of the insurance that is taken into account.
So do we have insurance for the McBride Fire, or does PNM?
Yes, we are working with our insurance company on the McBride Fire.
So can you tell me what the extent of the claims are, or the exposure is for the company?
Mr. Hearing Examiner, I object. We're getting far afield of the litigation expenses, which is what Mr. Sanchez is testifying about, and into potentially privileged information.
Sustained.
Well, let me narrow the question. If there's a finding of liability, or a finding of liability, does that automatically become how do you decide how do you decide whether it's deferred and becomes part of a regulatory asset that you seek to recover?
I believe that's the question that the hearing examiners asked us to address in the bench request.
Okay. Are you a part of that decision-making process? Is that a part of the prudence review?
I'm not sure I understand your question.
In the instance where there is a finding against PNM, finding of negligence, is that cost passed on to customers?
It's difficult to say in a particular case, but I couldn't. I mean, it's difficult to assess in isolation, but it's a part of our cost of doing business that sometimes there may be a finding that that perhaps we might have been negligent, but that certainly happens. But as often we you know, we receive claims which aren't valid and that we don't pay out on. So it's all part of the cost of doing business.
Do you review defenses that the company might make?
Mr. Hearing Examiner, again, we're getting very far afield of what this witness is testifying about. We're getting into.
Well, this
legal
witness has
defenses.
testified to his involvement in determining the prudence of legal expenses. And I want to know if he reviews arguments to determine whether they are prudent arguments to make. And those would be costs that would then be recovered. So I just want to know that.
Legal strategy?
Sounds like legal strategy.
I'm sorry, Mr. Elliott, sustained.
Okay, well then I have no further questions. Thank you, Mr. Hearing Examiner.
Thank you, Mr. Elliott. Okay, we've concluded the cross-examination, I believe, of Mr. Sanchez. Hearing Examiner Ryan, do you have any further questions or amplification on the bench request?
No, I think we've covered the territory well.
Okay, great, thanks. Mr. Alvidrez, when do you, and hang on for, are you there? Yeah, Mr. Sanchez is still there to answer. When might the company be able to provide the response to bench request number 6? Mid next week?
If you could give us till Monday, we have not had a chance. I have not had a chance to run that down. I'm sure people are already starting to work on it, but I don't know yet.
That's, we'll try and revisit that Monday, but let's shoot for approximately Wednesday.
Okay, we will.
That's not a dead certain date.
No, understood.
Okay, thank you.
We will do our best.
Great. I'm trying to, Mr. Sanchez, thank you so much for your testimony. It was sincerely good to see you again.
Yes.
Have a good weekend. You are excused.
They do have a.
Oh, you have redirect. I apologize. I'm trying to get us out of here before. I'm trying to get us out of here before 5, and I may fail. Go ahead.
Thank you, Mr. Sanchez. There was a lot of discussion about your response to Ms. Gould and your response with regard to potential or hypothetical merger expenses. Was your testimony in any way intended to suggest that there is another merger afoot?
No, it was not.
Okay. Was it in reference to what may or may not happen with regard to the Avangrid merger that's part of the appeal?
No.
Okay. So let me ask, just to kind of try and frame things in terms of what your testimony encompasses. Can you explain for us what your testimony addresses in terms of the company's future test year cost of service? Just you'd lay it out simply.
Yes, I'm supporting the prudence of litigation expenses that would be included in the annual cost of service. And I lay out an amount based upon, as outlined in my testimony, consideration of the base period expenses, and arrive at a number to support legal expenses to be included in the annual cost of service.
When you say annual cost of service, what do you mean by that?
The service that the expenses of running the business on an annualized basis.
That's my redirect. Thank you very much, Mr. Hearing Examiner and Mr. Sanchez.
Thank you, Mr. Alvidrez. Mr. Sanchez, again, thank you, very much for your testimony.
Thank you. It was
always good seeing you too. Always appreciated. Have a good weekend. You're excused. Okay. Unless we see you again and potentially on further cross-examination, you're available for that. If you're the appropriate witness sponsoring.
I'll
let me clarify. I'm sorry. If If appropriate cross-examination is requested on bench request 6, it is possible that you might be the witness that might be called to testify again,
Okay,
potentially.
okay.
I just want to make, okay, thank you.
Yeah, I
All right,
appreciate it. Have a
Thank
good
you.
weekend.
You too, thanks. So we have, moving forward, we'll have Mr. Sanders testifying first, I believe. Is that right, Mr. Alvidrez?
Yes, Your Honor, that's correct, followed by Mr. Heffington.
Right, and then Ms. Pino after that. And then could we please potentially have folks on deck from Tuesday, September 12th?
I know we were working on that. I haven't heard the latest. If you can give me,
No, yeah. I
3 minutes.
appreciate you working at it. That's all I ask.
Okay,
That you
we
are
are working. on it.
That's all I ask.
Okay. How
So-
about we can send out a note as to the witness
Okay.
order to all the parties when we settle that a little later today.
Please copy the hearing examiners. if you don't mind.
Absolutely, we'll copy the whole service list and the court reporter.
Because one of the things I want to do is revise the witness, just for my purposes and hearing examiner Ryan's, revise the witness list to see how we're going to be sliding in, because it's potentially moving forward to the 13th. Ms. Chan, that's about, we might be able to move her in since she has a long day. Or is she not available? That's the other thing I didn't look at.
I actually have our on deck people for Monday. I was provided that information. I knew they were working on it, so I can
Okay.
tell you what we've got. And so we have first, we'll have Mr. Sanders on the bench request, followed by Mr. Heffington, followed by Ms. Pino. And then waiting in the wings will be Eric Chavez, who is right now on Tuesday, Jason Peters. Following him, Yannick Gagne. Following him, and Mr. Gray. Following him, if we get that far down the lineup. So it essentially wipes out Tuesday. We'll have to see what we'll do for Tuesday, but that's what we've
Right.
got ready.
And that information is contained for potentially for what we would do on Tuesday in your pre-hearing memorandum. And I haven't checked yet to see if Ms. Chan is not available on Tuesday, the 12th, for instance. Do you follow me?
I'm sorry, I don't.
Okay, well, it's my duty to go through what you helpfully put together at the beginning in your pre-hearing memoranda about when witnesses might not be available on which days. And that's what I'm referring to, is inquiring into whether Ms. Chan might be available. Or if not Ms. Chan, if she has to testify on the 13th, could Mr. Kotzes
Ms. Chan
slide over?
Ms. Chan is available on Tuesday.
Okay. Do you see what I'm trying to do that I didn't fully execute? So apologies there. All right. So what I have for Mr. Sanders so far, what I've seen on email from Ms. Nanazi for New Energy Economy and Sierra Club, Mr. Marks, is 15 minutes each of cross-examination on bench request response 3. Do it. Obviously till tomorrow, I'll be looking for responses. I'm not going to ask parties yet. They haven't been expected to review that unless they're ready to volunteer that now with regard to Mr. Sanders. And I'll just open the floor to that. Anybody? No? That's fine. So what else do we have to address? I think those are the housekeeping matters that I had. Anybody else? Very well then. Unfortunately, it's after 5 by almost 4 minutes. I apologize for that, but I wish you all a very restful, relaxing, and tranquil weekend.